Matter for Monday, my lord.
My lord, one matter for arbitration 37 petition, my lord, on Monday or Tuesday, my lord, for hearing. There is an urgency, old matter.
Old matter,
Yes.
Forward final hearing, but
after 10 days.
one ವಾರ ಆಗ್ಲಿ after ಒಂದು 10 ದಿನ ಆಗ್ಲಿ.
Another two
Lordship
matters for
adjust
admission, my
the
lord.
board.
This is green bench matter, my lord, admission Monday or Tuesday, any date me.
New matters will come, no issue.
Next week, my lord. Madam.
Lord, this contempt matter, my lord. Contempt matter.
Madam.
Lord, this violation of, my lord, order dated 8/9/2021, my lord, for the release of compensation amount, my lord, for the formation of the road. That has been not been complied with.
Whether it is an interim order or final order.
Final order.
They are not listed. Within 5 days listed, if it is a fresh matter.
My lord, education matter, my lord. Eighth.
One second.
Madam, take the memo.
If it is a fresh matter,
Visual case.
This one,
it will be listed within 5 days.
this one.
Ah, see that,
It will come
provided
within
you
5 days.
remove the objections,
I removed that.
it will be listed, yes.
My lord, education matter, my lord. Board exam for 8th and 9th and also SLC exams is allowed. Announced, my lord. Kindly out on Monday, my lord, because of urgency, my lord.
Education matter.
Monday.
My lords, this is a fresh writ appeal where a when this is a fresh writ appeal, my lords, in which the notification appointing drivers has been quashed, my lords. In connected matters, your lordships have already granted stay. May I request for it on Monday, my lords?
Connected is already, which date, madam, they have posted?
My lords, there's no date given. Your lordships have admitted it, my lords.
We'll take.
I'll hand over the numbers of
Tues-
the connected.
Tuesday,
appeals.
Tuesday.
Tuesday, very well, I'm raising it.
My lord, I am the party in person in a temple matter, my lord, where my lordship was sitting on the roster bench as say, pass an order directing the DC to act as a receiver, and the receiver has been appointed and 150 crores of the gold and money has been seized as per my lordship order. Now, in view of the scheduled procession of the Shivratri on 5th, my lordship order has to be modified. I moved a memo thrice before the registry to constitute the bench of my lordship justice, TGSJ. Bench has not been constituted. There is an extreme urgency on 5th of March for
Approach the
memo
registered
before the
judicial
registrar.
yes, memo has been moved thrice before the registry.
To
My
give to the-
lordship bench has to be
to
constituted.
give the memorandum.
Yes, thrice I'm,
Not here, to the registered judicial.
yes, I gave the memo thrice, my lord.
So it will be done.
Yes, thrice I gave the memo. In spite of the memo, bench has not been constituted, my lord.
Whatever is appropriate, we pass the order
Yes, my lord.
after seeing the file.
Yes, ma'am.
But not here. Not
Alle,
here.
RJ, you move the memo before the RJ.
I have forwarded it to Raj.
Yes, my lord.
My lord, one matter, fresh matter, my lord, for preliminary hearing, writ petition, my lord.
It will come once you remove the office objects.
Office objections are complied, my lord, it's filed 1 month back, my lord, not been listed, that's what.
No, it has to come by with, if it's a fresh matter, it has to
It's a
come
fresh
by
matter.
5th day.
It's fresh matter, office objections are complied, but matter has not been listed.
To check up the, because the yesterday instances were that the office objections were not removed.
No, it's a
The-
complied, my.
You people are mentioning for early listing.
Not pending appeal.
So if it is not removed.
It's all been removed, my lord,
we
objections
didn't-
are complied.
Have you checked it? Verified it
We verified, my lord, yes.
within 10 days.
My lord, Monday, my lord, it's a, sand is lifted from the river.
Mining matter.
Alla, mining,
so
it's
no
not
urgency,
about
let
mining,
it
my lord,
come.
it's a, alla, it's my lord,
I have lordship is telling 10 days.
alla,
I am
it's a
telling to-
license has been given to the lifting of mines
Next,
from
next,
the,
next,
alla,
next.
there
Don't
is some,
waste our time, sir, please.
alla, Netravati, this river, my lord,
ಅಲ್ಲ,
ಅಲ್ಲ,
urgency ಏನಿಲ್ಲ, demolition ಏನಿಲ್ಲಲ್ಲ.
alla, but it's a river, the water will not, water will go, my lord, that's what.
Will
Now,
Netravati
from the
river will
vented
take
dam, they are
its
lifting the
its
mine.
own,
Alla, from a vented dam, it is permission is given to them only to lift.
All
during-
matters cannot be listed early.
Alla, only April, May, that was, permission is given. Now they are lifting it in the month of January itself, my lord.
Not before
In
10,
violation of the,
10 days.
not
10
before
days.
10 days. Yes.
Not
yes.
pending appeal, my lords. Date is given on 15/3/24. I am seeking for preponement. For this reason, my lord, the no confidence is motions against previous Adhyaksha.
File IA, file IA.
Lords, my lord's fresh writ appeal, your lord. It's
It
on,
will- Madam listed,
no, your
it
lordship.
will be listed once you remove the office objection.
It's already complied, your honors.
When it is
It's already been 1 month that we have complied with the office.
1 month,
Please, your honors.
Note down
Your-
in the memo, madam. Why it is not posted even?
Why
after
it is not
complaint?
Grateful, Your Honors.
Fresh matter, my lord. I've complied with all the officers. Fresh matter. It will be
This
listed.
matter will automatically come on 5th day, sir. Why are you moving memo?
Some urgency in the matter. Kata enters.
What is the urgency, please?
Kata is standing in my name. The single judge has directed Kata to be changed back to my brother's name.
Single judge order.
Yes.
Yes.
One more, and this is a railways matter. We are for respondent. This honorable court had directed a survey in the premises. We have also conducted survey and they have to pay the deficit amount to the railways. In view of pending matter, they have also paid which was admitted amount. After survey, there is a new amount which they have to pay to the railways. Therefore, we request this honorable court to oppose this matter so that we can recover the new amount.
Urgency, sir, if it is, there is any urgency,
and
then
the
only
amount-
move, sir. Otherwise, you wait for the, it's done, let it be posted in regular course.
Yeah, the railways, my lord, has to recover the amount. He's running the shop.
So
In the
you are
premise.
moving the memo on behalf of railways.
Then our
Told.
The complainants retired from the service, my lord. Accused not settled the pension and the requirement to benefits, my lord. So
it will be listed. It will be listed.
It will be listed, no
Listed.
issue.
Don't worry.
Lordships,
No, we are not accepting. It will be listed. Provided we are instructing the registrar judicial to start listing the matters. Yes.
Lordships, I'm the party in person. I am the complainant. I had filed a civil contempt petition 450 of 2023. The Lordships had heard the matter. The orders were passed on 30th October. And I had further on filed an application for correction on the order. And the matter was heard on the 5th December. However, I have not seen the order for the application on correction.
Then you
in
please
the,
go to the registrar judicial and where there you take his assistance and verify, madam.
So for the order which has to be uploaded.
Yes, go to registrar judicial.
Inquire what is the status.
Okay, because I didn't see it in the site, neither I could get. a
But we
certified
cannot
copy.
open the system and check and tell everything. Please go to the registrar judicial. What we are asking, please capture it.
And there can't be mentioning of such things. You
Okay,
go
sir,
to-
I will go to the registrar.
The respondent is seeking for issuance of central government health card, my lord. There is stay in this matter. May be taken up for hearing, my lord.
What is the urgency, madam?
Lordship,
Memo, you can't casually move the memo unless you explain the urgency.
health card was supposed to be issued, my lord. There is
It
stay.
will come.
It will come,
Will
it
come.
will come. We are, Lordship is streamlining the postings and everything, don't worry. Memo in future, moving of memo will be reduced.
My lords, it's a mining matter. It's an old matter, my lords. This honorable court had passed an interim order to deposit certain amount of money. Then they will allow the to carry on the acquiring activities. But even though the petitioners the petitioners have deposited the amount, they are not allowing the petitioners to carry out the acquiring activities.
No
my lord.
urgency.
It's
Mining,
been
sand,
2 months.
everything,
It's
no-
been 2
no
months, my
urgency.
lord, since they have complied with the order.
In
Since
the
even
regular
though-
course, sir.
any date may be given, my lord. Any date may be given.
ಹೇಳೋದು ಅರ್ಥ ಆಯ್ತಾ ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನೋಡಿ.
My lord, it's been 2 months since the
ಹೋಗೋದೇನೆ
order.
ಡೆಮೊಲಿಷನ್ ಏನಾರು ಇದ್ರೆ ಹೇಳಿ ಅಷ್ಟೇ. ಕಲ್ಲೊಡಿಯೋದು ಮಣ್ಣಿಗೆಲ್ಲ ಮೆಮೊ ಮೂವ್ ಮಾಡ್ತೀರಾ ಹೊಸ್ದಾಗ್ ಬಂದು.
Even though the order has been complied.
ಹೇಳದ್ ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಇನ್ ಪುನಃ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರೆ ಸಾಹೇಬ್ರು ಗೊತ್ತಾಗುತ್ತೆ.
Your Lordship, yesterday I had moved a memo, matter pertaining to census. Today at serial number 39, one matter with respect of very same issue has been listed. And I am told that the matter pertaining to my writ petition is also placed before this court, but by mistake, in the cause list, it is not mentioned. So for the government,
Not listed today. My learned friend wants to argue that matter, taking me by surprise.
Wait. Ask them to do, that's the one. File is already there, they are not listed. Without listing, file is sent to the court.
Apply.
Kind permission. For non-compliance of office objection, first time, serial number 1. Shahbaz Hussain.
Wait, yes.
I'm seeking for an adjournment, my lord, with the lord's kind permission, serial number 65. I appear for
65.
the answering respondent. I have informed the appellant's counsel as well, my lord. Some inconvenience to it may be taken up any date, my lord, next week. We have intimated the appellant side.
Monday.
Monday.
My lord, when I requested them, they told that any date may be fixed after 10th of March. If your lordships are
Monday.
Monday.
It is for preliminary hearing.
I have.
Admission and preliminary hearing, no adjournments. Because we come here with reading the file throughout the night and you taking casually taking adjournment going away. Again, we have to read after 10th of March.
I'm grateful, Mondays. Mentioning it. So, serial number 1.
Appearing for the petitioner, a week's time may be granted in this matter to comply. with
Week's
the-
time.
Yes, your lordship. A date may be fixed. your
Serial
lordship.
number 1
Once
to
you remove your-
17. We will give one a single.
Serial number 6.
Serial number 1 to 17, 2 weeks.
Your last make time. Serial number 6.
Serial number
We have complied the
Serial
order,
6
my lord, we have
contempt.
issued.
Right.
6, my lord. I appear for complaint.
Complaint.
Issued an endorsement. May be permitted to charge.
Yes. Serial 6. Learned GA, serial 6. Learned GA submits that the order has been complied with. Full stop. Learned counsel for the complainant request for liberty to challenge the endorsement.
Yes, my lord.
Petition placed on record.
Endorsement dated 15/2/2020.
Endorsement dated 15/2/24.
Yes, my lord.
Liberty to challenge the endorsement.
Obliged.
Close.
Serial number 3, your lordship. 3 weeks time will be granted. Your lordship.
We are giving blank 2 weeks.
3 weeks because.
3 weeks or we will give you new one, 4 weeks.
One submission.
Much obliged.
4 weeks, but then you remove all the.
Register, we have for 6 weeks. We will give 4.
In serial number 1, your lordship, a date may be fixed. I'll comply with it in
4
1
weeks,
week.
4 weeks, they will give
Once
the
you-
date. Don't ask all those things, fix the date. They will give the date. You are regularly appearing in the court. Why are you asking for a date? All the files will carry date. Don't ask date.
No problem. Gratefully.
4 weeks. Yes, anybody in between 17?
Serial number 11, my lord.
11, please. What is your submission, sir?
4 weeks.
4 weeks, 4 weeks, up to 1 to 17, 4 weeks.
My lord, sir, serial
It
number,
will be submitted between the numbers. Yes.
my lord,
Ah.
20th of March.
Which one? Serial 8. Serial number 8. 23, 20th March, 20th March.
My lord, serial number 9, my lord. 2 weeks
Yes.
may be granted.
Huh?
Serial number 9, my lord.
4 weeks.
my lord, serial number 10, my lords. 2 weeks time may be granted.
4 weeks.
4 weeks. Why do you mean?
Up to 17, 4 weeks.
18.
Serial number 18, 2 weeks time.
You see, SC/ST matter, 210, madam,
My lord, in this matter is a little different. My
different.
lord, yes, a little, my lord may hear this matter and then.
Then comply the office objection, madam.
2 weeks time.
2 weeks. Serial 18, 2 weeks. Counsel for the appellant seek time to cure the defect. Post 2 weeks grant.
Number 19.
Appellant, 2 weeks.
Court fee, 2 weeks. 20,
20.
For appellant, 4 weeks.
4 weeks.
21.
1,
21.
none appears, 4 weeks.
22.
SC/ST. Madam, in this one,
My lord, this one, my lord, it may be called after 2 weeks.
4 weeks. There are several complaints are there.
23.
23, 4 weeks.
Boya Ramakrishna. 24. Monesh Kumar.
4 weeks.
25.
My lord, I pray for 4 weeks time, my lord.
4 weeks. Yes, madam.
Right.
GS 6.
26. The Mali Patil PS.
None appear, 4 weeks.
27.
For the petition, 2 weeks may be granted.
4 weeks.
28.
For appellant, my lords, it's an election matter. Kindly have it next week, my lords. I'll comply the office objection by tomorrow.
Next week.
Much obliged.
Number 29. Virendra Sharma.
2 weeks.
Number 30. Nagaraj 2 weeks time.
2 weeks.
Number 31. Shri Janardhan Ji.
4 weeks. None appears.
32.
Either 2 weeks, yarilla under 4 weeks.
32, my lord. 1 week time may be granted.
1 week. 2 weeks. Court fee, you have to pay court fee.
Yeah, I'll pay. 1 week time may be granted.
2 weeks.
33. Mr. Dhananjay Kumar.
Appearing for petition.
Madam, you have to pay court fee and 9 objections.
We will comply within a week time.
2 weeks.
Much obliged.
34.
My lord, I am for the petition.
Shriya.
4 weeks.
4 weeks.
Much.
35. Purnima.
None appears 4 weeks.
36. Mr. Satish Kane.
36. 4 weeks.
37. Uday Prakash.
2 weeks, my lord. 2 weeks.
2 weeks.
For orders. Number 38.
Appearing for
the petitioner, my
lord. May please the lordships.
Non-compliance of office objection
It
and
is
that
regarding-
pro forma it is, the office objection is that it is not. in
What
the
has happened is,
Forum
let
A.
me explain, Miller. What has happened is, when the writ petition was filed, the 2018 rules was not being followed, Miller. Subsequently, Miller, it was being followed. By then, Miller, we had already filed the writ petitions and one of them has filed the objections also, Miller. Therefore, I filed an IA praying that whatever details that was required, Miller, the pro forma is given. That may be accepted. That's all.
The office is raising objection that it is, both are not matching. At least if the particulars required in Forum A, if it is available here, then we will accept it.
Your Lordship, give me a short date, Miller.
Please verify.
Please, I'll do it.
Connect here, senior advocate.
Lord, in the connected matter, yeah, I just want to draw my laws. actually.
So translation, you have to furnish huge documents, sir.
I'll do that, madam. There are 2 orders that are passed by this honorable court on 28/1/2021, my lord, 28 and 28/6/2021, detailed orders in regards to the implementation of the Senior Citizens Act. State may file compliance, my lord. In the meanwhile, I will provide the translations, my lord.
Okay. Learned counsel for the applied
Petitioner.
petitioner submits that he will note he will furnish the translated copies of annexures mentioned in the, we will note card list, so on. Within how many days you will furnish?
So within 2 weeks, my lord.
Within 2 weeks. Accordingly, 2 weeks. Accordingly, IA 1 of 20 disposed of. Full stop. Now the report has to come from government. Madam.
For some time, it's 21, madam.
Full stop. Learned counsel for the petitioner submitted that there is an order on 8/1/21.
21/4/2021,
21/4/21,
28/6/2020.
28/6/21. So the compliance has to be made.
Please,
Learned counsel, I will note down and we will give grant.
In my case, they had to comply with the.
Petitioner submitted, there are 2 orders. One is dated 21/4/21 and 28/6/2021, where the response of the government is required.
In the first
Learned
case,
GA submit that, it will be at, Learned GA seeks time to complete the instructions. 4 weeks, 4 weeks.
in the
Yes,
first
sir.
case, Miller, there is a direction on 7/12/2020, Miller. That may be complied with by the minutes.
7/12/21, another one. 38 MB. Shri Puttige Ramesh Leonard Senior Counsel submit that an order dated 7/12/21 required compliance from the side of the government.
State government.
7/18.
7/12/2020.
20,
Sorry, ma'am.
no issue. So otherwise, GA 6, 4 weeks.
The
Yes,
date may be fixed, Mr.
100%.
Please, sir. Grateful.
Number 39.
This is that matter which was
The
moved
matter will
yesterday.
take it up later, let the another one will come end of the list.
With your lordship's kind indulgence, may seek, it may be taken up at 2:30 minutes. If it's
afternoon
not,
we'll
if
take
it's
it
not
up.
inconvenient to your lordship, otherwise we'll wait here and we'll wait here.
Let the additional, the another matter come in the end of the list, we will take up together.
Please, file has come, but it's not notified in the list.
Rotary, Roastery, the every list is reached before 1:45.
Please, oblige to.
So please wait.
We'll wait.
That's-
We'll wait.
40.
Question number 40.
My lords, I appear for the petitioner. My lords, this matter needs to be heard. Let a date be fixed once and for all. We can have a substantive hearing, my lords. Maybe instead of.
IA 1 of 23 stay filed by the advocate.
In fact,
for
we
the
have
appellant.
sought for a stay because the construction is going on. The matter concerns a site, my lords, which has been converted from a green plan to a civic amenity, and construction is going on. We have challenged it. Since the stay has taken a long time, let the matter once and for all be heard, my lords. Ultimately, we want
Service, everything is complete.
everything
madam?
is complete, my
Then
lords.
we close this IA 1 of 23 and post for.
My lords,
final
let it
hearing.
not be closed. Let it be there on record. 25th or 26th March, my lords.
It is consuming our this one space in the card list, madam.
My lords,
We
it
want
can
to
come for
save the
final
ink.
hearing. It can come for substantive hearing. Let the IA be on record, my lords. We ultimately have.
Learned, Srimati Jaina Kothari, learned senior counsel submits that the matter required substantial hearing. And IA 1/23 may be taken together along with
Yes,
the main.
yes, grateful, my lords.
Full stop. Since service is complete agide
madam.
service, sir.
Complete,
BMP.
complete.
Okay. We'll fix up a one date in the.
Yes, last week of March, my lords.
Delay ಇದೆ ಎದುರುಗಡೆ. Counsel for the appellant. Next time to cure the 2 weeks. ಎಷ್ಟು ದಿನ
2
ಬೇಕು?
weeks, 2 weeks.
2 weeks.
Number 42.
Much obliged.
TM Venkat Reddy.
R4, 14, 16 of the writ petition are not made as a party, sir. Please clarify. Why they were not made as a party? Person who have been there in the writ petition is not made a party in the writ appeal.
The learned single judge has passed the order without issuing the notices to the entire respondents. One thing, then the so originally I am the purchasers of 2 sites. So the third and second, fourth respondent have filed a suit for declaration, declaring that he is a owner. Then subsequently,
You are arguing the case on merits. We want you,
Sir,
why
sir,
your act
therefore-
4, 14, 16 were not
Sir-
made as a party here?
they are not related to our
No, the
party.
title of the original proceeding must match with the appellate proceeding.
ಅವ್ರನ್ನ ಮಾಡಿ amendment ಮಾಡಿ.
Look,
include
I
ಮಾಡಿ.
have already made, but I have seeking
Sir,
dispensation.
These are the basic things.
I have already made.
We can't waste time.
I have filed memo.
Do it.
Where is
Match
the
it,
memo?
match the
Show the
title,
memo.
that is the only.
I have already made my party,
One ನಿಮಿಷ.
but one memo has filed for seeking dispensation.
No, it can't be dispensed with. All parties in the writ proceeding must be parties here in the appellate proceeding. That's a basic principle,
Yes,
basic thing for a procedural compliance.
R1 V Krishnappa. ಎಲ್ಲಿ ಸರ್? ಇಲ್ಲಿ ಇಷ್ಟಲ್ಲಿ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲಿ ಮ್ಯಾಚ್ ಆಗ್ತಾರೆ. Full stop.
Yeah.
Council, urge CTM and Reddy learned counsel appearing for the appellant. Full stop. Submission is not accepted. The appellant has to correct the cast title incorporating the R4, 14 and 16. Full stop. ಎಷ್ಟು ದಿನದಲ್ಲಿ ಮಾಡ್ತೀರಿ? 2 weeks.
Number 43. Stirap Reddy.
I appear for appellate in this matter. Your lordship, the office objection is annexure Q and R not forthcoming in the petition copy. But what they have served, the copy in that we don't have that copy of
You
annexure.
are not
Q and
relying
R.
on Q and R.
We are not relying.
That counsel for the appellant so submit that the appellant is not relying on annexure Q and R. Counsel
Date may be
submission is
fixed, your
accepted.
lordship.
Counsel submission is accepted. Full stop. Full
We had filed impleading application in the writ petition.
stop.
That
What- Matter.
Actually, what the respondents herein have challenged the order passed against them in before the AC and DC. The order is against us, the order is.
Order passed
favor of
on
us.
IA 1/22 requires hearing prepare. You please prepare and come. Post
Date
for
may be
preliminary
fixed.
hearing.
Bill is good for hearing.
Number 44.
For the complainant in this case. please. For the complainant in this case.
Mr. BS
This
Sachin
Malad is
BS.
measuring about 6
We
guntas.
have preferred a writ appeal, my lord, sir.
That is.
In writ appeal number FR number 358 of 2002.
May I be permitted to submit, please, Milords? 6 guntas of my land, Milords, without acquisition, please, without adhering to the acquisition process has been acquired. There is a joint inspection that has been conducted, please, Milords, by the authority concerned in my presence. They have established, please, not 6 guntas they have acquired for the purposes of formation of a road. What I am seeking, please, Milords, in the writ court was, please, not compensation, please. That also. they
Let
don't
the
take.
writ appeal also come. We will take both together and we will take a call. We will hear both and pass it.
But my submissions are. Milords,
But
that
when they have
But
submitted
the
that they have filed the writ
joint
appeal,
inspection by the
contempt
authorities
can't proceed.
conducted, they themselves have established, Milords, 6 guntas of my land, Milords, has been acquired for the purposes of formation of a road.
Objections are
Sri
removed.
Monesh Kumar,
No, not
learned
yet
counsel
removed.
for the complainant.
remove the
The BS
objections,
Sachin for BDA submits that the BDA has preferred the writ appeal. Full stop. Post this contempt along with the writ appeal.
Grateful,
Yeah, number Admil, you please furnish. the-
grateful. I'll furnish. Now it is in FR number. We'll get it rectified and.
Yes.
Because the learned single judge relied upon an earlier judgment and then passed orders, Milords, in view of the earlier judgment of the Honorable High Court. So therefore, please, Milords,
So it is better you get the disposed of writ appeal also. We will
but it
proceed with the.
takes a
contempt.
longer time, Milords, I will be put to, Milords. Apply.
Number 45.
Lordship, in this case, bailable warrants were issued. It's a child custody matter.
Child custody matter in GNW order.
Is of an order passed by the Honorable High Court. What has happened in this matter, Lordship, is that there are several orders passed by the Family Court. And then the order was assailed before the Honorable High Court. And the Honorable High Court said for 1 month, you need to shift the custody of the child to the father. Because not a day of visitation was allowed despite directions of the Family Court. So what the Honorable High Court in the impugned order said, as an interim arrangement, for 1 month, the child should shift to the father. And thereafter, after 1 month, again, this decision for visitation rights will be reheard. But Lordship, what is happening is I'm not even being able to speak to my child over a phone call. He's my only son.
You are for father.
I'm for the father. Father is here, Lordship. Since the time the child was 9 years of age, the mother is not letting me meet the child. And I'm in litigation in court and I got several orders of the court. And the most interesting thing, Lordship, is that not a single order passed by the various courts has been challenged by her. She just wants to be in violation of orders.
What is the age?
The age of the child right now is 13, Lordship. But the child was 9 years old.
Why they are
I
separated?
speak?
But the child was of 9 years of age.
Why they are separated?
Lordship, because of the differences between the husband and the
We
wife.
know.
Sorry?
Since how long they are separated?
Since 2019 of November, Lordship. But since 2020, Lordship, I started litigating for visitation rights and custody for my child.
We'll endeavor to visit his right later.
Sir?
Is it possible to
They're
reconcile?
not letting me meet, Lordship. First, the order was that I should go every Sunday to my own house.
They are not ready to stay together for the interest of the child.
Lordship, the point is that he has already filed for divorce because of these circumstances which have existed. He's filed for divorce. And what she matter has been
We
referred to
want
me.
you to try.
The Lordship, I'll just say one thing.
to work
Matter
out
has
this.
been referred for mediation in the past. They say, you give me 2 crores, 2 houses, then we'll talk. Lordship, the point is an extortion the child is being used upon in this matter. With the mediation, in fact, before Justice Nagprasanna, when the matter was listed, he referred the matter for mediation. It's written in the order. And the mediation was only with respect to visitation rights. But they said, no, you give us 2 crores, 2 houses.
No, we want global mediation,
Lord, can I speak?
comprehensive settlement if it is possible.
No, Lordship, the fact of the matter is that I have not even met my child even once. I just go, like even now the child will say, I don't want to meet the father.
Now the child has already aged 13 years, he has
But-
attained the age of taking some decision.
Lordship, the point is that since 9 years, I've been deprived. And Lordship, there is, on 10th of February, I'd like to say one thing, Lordship. On 10th of February, when the order was passed, 2022, the child interacted with me because it was a consent order. When the mother also said, okay, you can come on Sunday and meet the child. The only difference was that time the counsel was not present in court of the mother. And then what happened when I spoke to the child on that day, I have a comprehensive recording of transcript. The child is very comfortable with me. But thereafter, when I went on Sunday, the child never wanted to come and meet me. And this is a tool because they want to deprive me of even meeting my child once. Child is not uncomfortable with me at all. I have so many pictures, Lordship, starting 1:30. I was the only parent taking care of the child. I used to be the one taking him to the school, to all the parent-teacher meetings, to all the dental treatments. I was the one taking the child. The child was absolutely comfortable with me. It's very easy to tutor the child. Anything. Which is why, Lordship, even for handover of custody, every time when I used to go to the house on every Sunday, there used to be a drama. Sometimes the grandmother's video recording, sometimes the mother's video recording. The police reports have come in this matter. The police is saying that the mother is making unnecessary comments. It's all on part of the record, Lordship.
Okay, wait for, we will hear her, you please keep quiet. Sir.
She is 14%.
Say you are 14%.
Lawyer
Going
also,
to-
yeah, Lordship.
Is your advocate?
Advocate.
No, I have not appointed any advocate because
Would you-
this is the
would you-
sixth case filed against me, my lord.
The
So I
advocate is
need,
sitting here, Lordship.
I'm not
Wait,
able,
sir.
I'm not able
You
to
are
bear the
ordered to talk.
cost.
When she is talking, why are you interfering?
I'm
This
sorry.
is the sixth case that's been put on me. And first is the GNWC case. And I was taking him for the High Court as well as to the lower court. He was coming whenever, like I had taken leave also for him and then I have taken him. And lot of harassments are happening. They
You are a
lot of
working woman,
police-
madam, you are a working woman.
I'm a working woman. I'm working in shift now. Still 4 o'clock I was working and then I've come here now. Just because there's a warrant that's been issued yesterday.
Because
And
you have to comply the order of the court.
I've been complying, my lord, and I've asked my son, like, please talk to your father, please, when he's coming, like, please talk to him and all. So he's clearly saying, I am not interested. Nowadays, when I speak, he's just closing his ears when I say about his father. So that's because he has seen so many things in front of his eyes that he's breaking open the gate. He has brought so many police to the house. And then they were threatening him, pulling him out of the house. So all this, he got frightened and he's wanting not to go with the father anymore. So that's the things that is happening. And continuous, yes, last week also I had my case in the lower court, and next week also I'm having my court cases there.
Let them go before the
So many days I taking off is so difficult for me. Lord, in the lower court also, they suggested, like, since divorce petition is filed, why can't you, like, please talk and settle all the things and we'll close the cases, but they are not willing to do that.
Lordship, may I point out
You
something?
can hear from
I'll
the
just point out
child
something.
itself. And I am the only earning.
Okay, madam, you please, 1:30, you come to the chamber. What, you both come in the 1:30 in the chamber, we'll record a statement and then we'll take a call.
When take a call, what?
Lordship, I'll just like to say one thing, Lordship.
What is your client doing?
Lordship, he is the managing director of a company. He is into the business of mapping as well as manufacturing drones. And he's got several awards by the government also. And the fact of the matter, Lordship, is that there are several pleadings which they are themselves saying that the child is waiting for the father to come in the pleadings. And how can they say now that the child doesn't want to meet the father?
Let the court interact with the child in the
Yes,
case,
yes.
and then we will take a call.
Thank you, Lord.
Lordship.
Number 46, V. Anand. V. Anand.
Appearing for appellant in this matter, Lordship. Not weeks,
Translated copies of
Please.
annexures.
please, weeks time may be granted to.
Learned counsel for the appellant submits 1 week time to submit this translated copies of annexures referred in the list, so and so number. 2 weeks time.
Much obliged.
Number 47. The
Lordship, the first office objection is regarding the annexures of statement of objection not being there. They were not served upon us, your Lordship, and we are not paying reliance upon the same.
Yes, so be not filed in the writ, sir.
My lord, my record show it as filed, but I can supply her a copy. I can give her.
Then-
I'll do that. I'll do
Your
that.
Lordship, the second office objection
Yes.
for the delay, the judgment copy was received by us on 4th of,
Madam office has noted calculated 5 days of delay. Go to the office and clarify.
grateful.
Yes. Counsel for the respondent submitted that the statement, copies of the statement of objections filed in the writ will be furnished to the appellant within a week.
Yes.
Full stop. Counsel for the appellant to clarify the delay of 5 days calculated by the office. 2 weeks.
Grateful.
For 48.
My lord, there's a delay of 321 days, my lord.
Annexure, sir, annexure page 225,
I'll-
26. And
do the
annexure
needful.
P6 to be produced.
I'll do the needful.
Counsel for the appellant submit that the copies of the annexures will be furnished. Yes, Tina, how many time you required, how much of time?
A week, sir.
Okay, 2 weeks.
Lord, this matter, my lord,
That's connected.
connected matter. This
You give the date in connected. 28 March, 20th March. And counsel for the appellant submit that there are connected writ appeals. Give me the numbers. Please note down those numbers, man. Post along with. 49 also same.
No, 49 can be disposed, my lord.
Yes.
My lord, the learned single judge, my lord, followed the apex court judgment in Ganpati Dealcom. My lord, against which, my lord, review petition is filed, my lord. That's why we have filed the writ appeal now. My lordships have been disposing the matters, my lord, with liberty to revise. If we succeed in the review petition.
Since review is, you can.
Review is before Supreme Court.
Please.
Then until review is decided. To file it.
No, they want to withdraw this liberty, if that review, we can revive.
So in some same terms.
Please.
Some order is passed by this.
Yes, madam.
Yes.
Previous bench, same order.
Learned, same identity.
Same order. In writ appeal 1060 of 20.
May I make one submission, my lord? The previous matter, my lord, my lordship may kindly issue notice, my lord, because the connected matters.
There are some councils, some the annexures.
Please,
you have
please,
to
I will,
publish,
I
na.
will, please.
You do that. On 20th, if other side comes, you will direct them to take notice.
Number 50. Mr. KBS Manian.
for the complainant.
Matter, my lord, I undertake to appear on
This
behalf
to
of the
A2 and
accused, my
A6,
lords.
so what happened to the service to A2 and A6? A1 is dead, sir, Manian, sir.
Yes, please. my lord. All served.
Yeah. So A2 and A6, we have to wait for the service.
Service, my lord, non-filing of reply by served A3,
Furnishing of service report in respect of A6,
only A6,
Commissioner.
only A6.
But here also A2 in the card list, so what about the fate of service of A2 is not forthcoming.
Right. But A3 to A5 was served
Hmm.
and A7 and AT are also served. So they are not here. So for them, warrant may be issued. For the rest,
Let the work for remaining complete, then we will take up what.
all right, my lord.
Lord, for the corporation, I'm appearing, my lord. My name may be shown, my lord.
You are appearing for corporation, sir, BL Sanjeev, Sri Learned, Sri BL Sanjeev Learned Council.
EBMP, man.
You are taking notice for.
5, 7 and 8.
A8.
5, 7 and 8.
5, 7, 8. For 7 is Dayanand, DC.
I appear for who's A3 and A4.
5 and 8 you take, 7 GA.
7, notice may be.
Notice, sir.
I
Now what has to go as per, as requested by Mr. Manian,
take.
warrant.
I take. A3 and A4 are private parties. Warrant can go to them, my lord.
Learned
They have to have some
Council
respect
take
for the court
for
proceedings.
A5 and A8. Learned GA takes notice to A7. So they have taken notice, let them file their counter. Let the service of A2 and A6 complete.
A3
What
and
about A1?
A1 is no more. So we will take, against her it lapses, but we'll see what really happened. My lord, but A3 and A4 are private parties.
Of notice to A2 and await service of A6. A3 is served, absent, issue bailable warrant for rupees 25,000.
A4 as well, A4 as well.
A3 and A4.
A4. Private party.
Date code.
Grateful.
Please give the date.
And A7 may not be a necessary party, not because direction is not to create third party interest on the property. It is between the list between the private.
We'll submit on merits. We find there's a specific direction to the statutory respondents or accused to ensure that no third party rights are created. There is a specific order.
See, any of you are
Let him
appeared.
file his reply, my lord. We'll respond to that.
You make same submission in writing.
Please, we'll rejoin. Grateful.
Please. I appear for the accused in this matter, my lords.
Naturally.
Yes, I appear for the accused in this matter. I appear for the accused in this matter, my lords.
File the
52,
Please.
52,
51.
51.
51 contempt. Okay.
Praying for 2 weeks' time, my lords, I'll file my reply, my lords.
Grievance, you have to attend the grievance of the
Please, my
petitioner
lords.
within 3 months, sir.
Please, my lords, I'll come back, my lords. I'll check you, I'll complete my instructions, I'll come back, my lords. My lords,
No,
kindly grant me
so
2 weeks'
no
time.
instructions, only complaints. Sir.
Please, my lords, I follow, my lords. I follow.
So complaints will be made within 3 weeks.
Lords, kindly grant me some time, my lords. I'll ensure, my lords.
We
We will
file
direct the physical appearance of the A1.
I follow, my lords.
The advocate
Order
must
is
bring
passed
it.
in 2022.
I follow that, my lords. My lords, I don't have this one, my lords. Hence I'm on my occasion, my lords. I'll ensure, my lords, I'll get back.
Learned counsel for our ಹೆಸರು note ಮಾಡ್ಕೊಳ್ಳಿ. You are for A1 ಅಲ್ವಾ?
Please,
Jaykumar. Learned counsel for the A1 3 weeks time.
Please, my lords.
Why you read 3 weeks time, sir?
2 weeks' time.
Do it
I'll
within
do it.
1 week.
2 weeks' time be granted.
2 weeks. To complete the instructions.
Please, my lords. I'm grateful.
52, I represent petitioner, my lord. Regarding respondent 2 and 3, on the last date of hearing, learned counsel has undertaken to appear on their behalf. Savela.
Notice to R2 and R3 serve ಆಗಿದೆಯಾ ನೋಡಿ, please check it. Awaiting service.
Shilpa Shah was ordered to be take notice for respondent number 2 and 3.
2 and 3 like not direct. Shall we direct? Full stop.
It can be directed, I am permitted to serve a hand copy to them.
Service of notice to R2 and R3 is awaited, full stop. Learned counsel for the petitioner seek permission to serve the notice to the standing counsel for R2 and R3, Srimati Shilpa Shah.
And there is small element of urgency. Reason is, now this Bangalore, Chennai Corridor Road, they are constructing. While constructing, a link road they want to put up in near this Kolaturu village. This this
They are asking for a construction of a particular village.
this link road.
Proposed
if they-
alignment, they are
One
complaining
minute,
of some
I'll make-
inconvenience.
The link road blocks my ingress and egress to this village as well as 19 other villages.
Now we have to complain, Shilpa Shah madam,
Yes,
she has to come and letter appear and we'll see, sir.
A little short date.
Direction is to be, she has to complain, she has to communicate to the officers.
Since last year, we made several appearances to the Honorable Prime Minister also. This is the inconvenience caused and even to the Honorable Union Minister. No, there is no reply and no response also. A little short date may be given, madam. Otherwise,
2 weeks.
please, madam, one date may be. Please, madam, I am obliged.
What up, sir? Tell the date openly, Joragi.
21-3.
Yeah, let them note down and they go with peacefully. They should not feel that date is not given.
Right, madam.
Because it has to percolate from quartile number 1 to other courts.
For the petitioner, this matter pertain to the,
State respond.
They have taken steps.
they have filed the objection now.
File the counter.
Yes.
The matter is, main matter pertain to your lordship, from Bangalore International Airport which enters to the city on Bellary Road.
After they counter it, does
Yes,
it survive substantially? it is-
80% of work is also executed.
They are doing it. Now, in the meanwhile, what happened, your lordship? This court expanded the scope of this public interest in such a manner that to find a ways and means how to decongest the traffic in Bangalore city, because people fear, and accordingly suggestions were given by me, by the petitioner, as well as the
They will
government has
consider-
filed it.
they will
In the
consider-
meanwhile, what happened, your lordship?
We have
I will
filed,
consider your suggestions.
The suggestion, they have to look into it.
it has been considered, my lords. We have placed on record the memo also in the proceedings which has been drawn. My lords, the main petition is pertaining to Ballari Road, where they seek particular stretch, my lords, where they want an expansion of the road. Different affidavits have been filed before my lords explaining, we have already explained, the traffic congestion has considerably reduced. We have also given the technical experts report. Now the petitioner on the last date of hearing files another memo for direction, my lords, where in some other places a traffic island has been created for the pedestrians to stand before crossing the road. And now he is seeking for a direction that these islands created are again causing congestion. My lords, for the same, the Brihad Bangalore Mahanagar Palike have filed their objections with the technical expert report. Why such a traffic islands have been created? Because people who have to cross different roads, my lords, they have to cross and stand in some place. And that is their main objection, my lords. This petition may not.
This is the Indian Road Congress guidelines for.
I don't think there was any difference.
Now, your lordship may look into the affidavit filed by the BPMP, your lordship, which has been adopted by the state. Filed on 29th, your lordship.
There are some photos.
Before that, I want to, lordship, kindly look into my IA, where I have produced the photographs and also government order, where the permission is given to make island traffic beautification. IA 1 of 2024, your lordship. Filed on 16th December.
Second one.
Because the Bangalore, we are having daily, people fear to move around, basically Bangalore traffic. IA 1 of 24, your lordship.
IA 1 of 23.
Filed on 16th December. 16th December.
The response of the state, my
Well,
lords,
just-
no
I'll-
rejoinder is filed by the petitioner.
Lordship, in this matter, Kindly translated copy relevant portion, annexure D, your lordship. Page number 12.
These are for the pedestrians.
What has happened? In the affidavit filed earlier to the response of 12th September 2023, the traffic police have filed an affidavit saying that in the high ground circle where earlier it was circle, they removed that circle and made the free flow of traffic. Now what they done, that island which was there, now they shifted to Race Course Road.
The islands they have created.
And again it is,
Now it was causing hindrance to the people. Now they are removed. These are the island where the police is. Only these are the islands. Island for pedestrian. But it is having a nuisance for the vehicles because the road width is still come down.
Para 4 and
now
5
their
was
own,
answer for
their own affidavit, BBMP, your lordship, may kindly up, along with that photograph, your lordship, kindly look at the affidavit filed by BBMP, which is an order by government. 29-2, your lordship. Affidavit filed by BBMP.
On affidavit, yes.
It reduces the
Page
width
number
of the
6,
road.
your lordship. Page number 6.
As of island.
Page number.
Earlier, in the
What,
same
no,
place,
just,
there is-
what did, just a minute, what the traffic police are requested the BBMP to see that, straighten the road, then put the signboard and put the traffic signal. That is the request, page 6, your lordship, translated copy. Relevant Kannada version is in page number 4 and 5 of the affidavit filed by BBMP. Page 6 is the translated copy. They only requested to remove the bottleneck.
That they have to Indian Road Congress guideline that. IRC. There all over the affidavit and affidavit. They will be asked.
They only asked to rectify the deficiency. Page 7, you lost.
That's already said. They are just only to follow.
all these were taken care of. Earlier, Lord, there was no, Lord, signal lights. There are signal lights put in now. The traffic, the free flow of traffic is there.
Only question which may boil down is whether you are following the IRC standards.
Yes, that's what we have said.
In Island.
Yes.
in Island.
Para 6 confirms the
Para
same.
6 has-
Affidavit, they say so.
You are for whom?
No,
We are for the state, my lords, we have adopted the same, because BBMP is the main person who's taking care of, we have adopted.
We are executing the work, Lord. IRC standards, we have, there's a team of officers, Lord, including the police, Lord, we have taken suggestions, have done.
The chief engineer has
So
filed the
petitioner is
affidavit.
not an expert in the field, Lord. I do not know. To his perception, if it is not, Lord,
It's not filed any expert report to
the
that.
government
effect.
order issued by the government, urban development, there is no such,
The function of the court is only to,
then they,
to activate them. They've activated themselves,
The-
taken steps.
the traffic police want the junction should be free from any curves. Now by virtue of this island, again, there will be a small curves and all thing, and there is a big platform they are constructing.
And an extent court can't go on monitoring.
And there is no work order. There is no work order also, Lordship. The, may I just make point out the government order, which is the approval is there under the Chief Minister project, Your Lordship. Annexure D, translated copy,
how it
wherein
That is
just
out of the
permission
package.
is given to put up, just a minute, put up a island in the Steel bridge is there, there's a Shivananda steel bridge. Below that steel bridge, the permission is given. That is the permission which has been granted by the government. But now they shifted that instead of in the steel bridge below that, they say dead space. Instead of, they want to beautify that place. We have no objection as far as beautification of any junctions are concerned. The issue is that there cannot be again an island, because similar type of island was there in High Ground Police Station. That has been shifted now to Racecourse Road. That is, there is no approval. Kindly see for a moment, Annex D translated, relevant portion of translation, you like. Shivananda Circle is the approval, not the Racecourse Railway Junction. There is no approval also. The state government has also not responded to that.
Grievance is that
Government
where,
order is not.
Thought you are doing some work without approval and
Yes.
That is not the case.
Below the any flyover, they can do it.
Is so technical about it, not the writ petition is meant for a particular stretch. That stretch we have done it, he has agreed to it. Now he is going on including one after the other. But there is number of work has been given, my lord. He has not, if he says not a particular thing, we can focus on it.
then to another, one has to reach it.
We can
Page
focus on it.
13, your lordship.
Not,
Page 13 of my application, you may read where the sanction is given, page 13, your lordship. 13 of my application.
You guys. No, only in the circles, junctions.
Similarly, they are doing it all other places now, your lordship. Once it is permitted.
Do you need such a large island?
Please.
Such a large island do you need?
It's a large area.
Why so large?
Why such a large islands are required?
It was a earlier road with.
My lords, I'll explain, my lords. It's also because the race course is there, my lords, where the lot of pedestrians are there in that road. There are something like 6 junctions which comes and stands there. People need to stand till the vehicles pass. So that is the reason an island is created. It is for the pedestrian friendly island, my lord. People can't stand on the road. They need a space.
Especially during races, my lord, people used to just walk in and
Thousands
walk
of
out.
people
Yes.
walk into the roads, my
They are not the issue in the PL, only
Yes, sir.
pedestrian interest.
Please.
We are only concerned with the interest and facility.
Yes, to Lord, why I am mentioning, because the affidavit filed by the traffic police earlier, and also the letter of request is to make the road free flow for traffic. Now by virtue of this island, which is in between, and again curbs are coming. If your lordship look into if you appoint any commissioner, they will know how it will be, because curbs are there, lot of curbs. Again, more number of curves than earlier. It was only one curve was there, going towards from Racecourse to, from Steel Bridge, Shivananda. Now 3 curves are there now, actually, basically intersect. And they put the signal also. Signal,
They are already
for signal there is no problem.
The movements.
So only thing is that earlier it was a circle, your lordship, earlier it was a racecourse circle, that has removed it now earlier. And then they made a free flow of traffic. So now the police also wants make it widen the area so that free, and also there was horses were there, which was blocking the view of the traffic earlier. So that has been also removed.
At present, on the race course road, everything,
They removed.
nothing
Yes.
works here going and everything is complete.
It's complete.
Because why I am saying that
Because
this
we are
court is,
also moving from here to our judicial academy.
Yes,
no, if they are,
Because
once they
judicial
allow such
academy, another
things
side
have
goes to
happened
magistrate.
without any approval, the government order has not given any approval for that place.
So we are
It has
not
given
concerned
at
about the
Shivananda
approval and,
circle.
anything. If you want to do free of cost, you do, sir, wherever you want.
Because after all, we want a free flow of traffic. So that's what we want. They have to take care of that. Because this court is since looking up to the issue regarding the decongestion of the traffic. And also suggestions were given.
Now the
They have to look
purpose
into
of
those
your,
suggestions.
now you are, by virtue of the affidavit, now purpose is served. Then what else remains in the writ? Formally we will close, since the compliance is done, we will formally
We'll
close.
pass the detail.
Yes, ever, whenever required, we can move later. No, we'll pass a detail. Yes.
For orders on Tuesday. Tuesday is which date?
Tuesday and fifth.
Fifth.
Sixth.
Sixth.
Grateful.
Is what? Seventh is working.
7th is working day.
Let it
8th
be
is
seven.
seven.
Great.
And as far as other aspects, my suggestion may be kindly be, let them give response. This court sought for a response from the government. So
What did he
traffic
place
police, let
Sir,
them give
whatever the
response.
response you want from the other side, give
Yes,
it
sir.
in a bullet points. These are the points.
Yes, correct.
They will also respond in a bullet
sir.
point, so that we can
Yes,
interpret in the order.
All, I have given all this.
Except, going to the
Yes,
bulky and
Lord.
everything, you
Do
know,
it.
you both know what is
Yes.
the crux of
Yes,
the
Lord.
case.
Even there, I issued, the government has also, traffic police issued a circular. Heavy vehicles should not enter the city, and also
Suggestions.
all
you
these
want
things
to
are there.
give, You
It's
give.
placed.
In a bullet point, as my brother is rightly.
Yes.
saying. Not in
Or
detail.
the Sri J.R. Mohan, learned counsel for the petitioner, learned additional advocate general for the state, and Sri N.K. Ramesh for the BBM. Full stop. Both the parties are requested to exchange their bullet points, which required to be considered. Post on 7th, stand over to 7th.
Great.
Please.
54 and 55.
But here, my lord, the petitioner is a medical student who, my lord,
Farah
was-
Fatima.
My lords, I'm appearing for respondent number 3, my lords.
University, madam.
In 54, I'm appearing for respondent university, my lords.
Madam, university you are appearing.
this honorable court, my lord, on earlier occasion, my lord, permitted us to take examination and
The next matter is same.
Identity.
Please, my lords.
Both
My
are-
lords,
As
may,
far as the IAS are concerned, it may be considered.
my lords,
Main issue is not whether the admission so made by the institution is irregular or per se illegal. That is, students are studying, man. not-
Legality of their actions. They are before us.
my lord,
What is the infirmity or illegality?
my lord,
They have admitted the students on their own whose names are not found, my lord, in the list of students.
Place of 3 other who are,
Yes,
who have left.
yes.
In place of.
That's the issue, my lord. That will address, my lord, on the main.
my lord, now, my lord, on earlier occasion, this honorable court, my lord, permitted us, my lord,
Supplementary examination.
to take part in the supplementary exam. Earlier, to that, my lord, in the main exam and as well as declare our result. Now, my lord, this court, my lord, since permitted us to take part in the supplementary exam, I am requesting, my lord, this honorable court to, my lord, announce the results, my lord, of the candidate.
If you fail, then what is the consequence?
my lords, may
My lord, I cannot go to the next,
For supplementary exam, they will seek permission.
Further again.
my lords, may I make one?
Earlier you were permitted.
permitted, then,
Again
my
you
lord,
are you
this
failed.
honorable court permitted us, my lord. My
My
lord,
lord.
earlier we were permitted.
Failed.
My lord, then, my lord, results were announced, my lord, by this honorable court. Then we failed, my lord. One of the students failed. 3 students were there, 2 students in the first matter, 3 in the second matter. In each case, my lord, 1 student have failed. My lord, this court permitted us to take part in the supplementary exam. Now, my lord, we are seeking, my lord, a direction, my lord, to them to announce the result. As earlier already, my lord, that announced.
They will seek for equity at the end of it. Before that, we have to decide.
My lords, may I make one submission, my lords? On 25/1/2024, there was a clear-cut instruction and condition by this honorable court saying that to the condition that the results thereof shall not be announced. Further, no equity shall be pleaded by the said petitioner on the basis of this interim order. My lords, in spite of there being an interim order, the petitioner number 1 has filed one more IA, my lords, seeking for announcement of the.
Equity reference to the merit of the case, not with respect to that examination.
Please, my lords, if they fail again, they will file one more IA, my
So
lords.
this honorable
seeking
court,
for-
my lord, your lordship may kindly see the order dated 7/11/2023 and, my lord, the order dated 10/1/2024. My lord, in both the cases, my lord, both the orders, this honorable court, my lord, has permitted us. My lord, this results also might be announced, my lord, without, my lord, we will not claim any equity.
We don't permit them to write the examination, then it can't be written.
So how many attempts are permitted?
My lord, we are still in the first year MBBS, my lord. 3 more years will be there, my lord, once we.
Exams.
Exams, my lord, once we pass this, my lord, again, three terms will be.
So any number of time supplementary after.
My lord, this was the
supplementary.
first, my lord,
Very correct, my lords. Four times, four times, four attempts,
First year, only 4 attempts.
4 attempts.
4 attempts, my lords.
So then you declare the result. What is wrong?
I leave it to the consideration of this.
Place on record the result.
Please,
Inform the court.
please, my lords.
So already it is stated that in the main matter, no equity will be.
Please.
The merits of the main matter will
Amendment
be.
might be
Maybe
heard
heard,
on
my lords.
First week of April, not will be.
Very well.
Orders on IA 3/24. Full stop. Shri Bipin Agde, Learned Counsel for the petitioners. Shri Ramesh NK for the KA. And you, Madam.
Anuparna Burdolai for response number 3. my lords.
Anupama Varlade for the university.
Please, my lords.
In 55, I'm appearing, my lords, for university.
Both common orders, in both common orders.
Please.
Identical orders. Full stop. The petitioners have written the supplementary examination by virtue of the order of this court dated
25/1/2024, my lord.
Vandrali 25/1.
There are both the same date.
Same, 25/1/24. Results of the regular students has already been announced. Petitioners requesting for announcement of their results also. Full stop. By virtue of the order dated 25/1/24, the petitioners are not claiming any equity. In view of this, the university is directed to announce the result of the petition.
Yes.
Let's date may be fixed, my lords, after 2 weeks or 3 weeks.
Yes, first week of April.
April, Your Lordship.
Date may be.
Hand over to for hearing.
You will place on record. You place on record the result.
Please, my lords.
University is directed to
Small-
place the result
Please,
of
my
the
lord.
petitioners on record.
Oblige me.
A1 3/24 accordingly disposed. Same.
Right.
My lords, I appear for the appellant in this matter, my lords. I pray for 3 weeks' time to file rejoinder, my lords.
Rejoinder to IA1, madam.
My lords, rejoinder to the statement of objections by the respondent to the main matter.
They have filed the.
Hearing,
Please, my lords.
it was your section 9 application.
Please, my lords, it is mine.
Section 9 is rejected now. Of course, hearing the application, hearing the main matter is practically the same because it is on security, my lord, which they're asking for. An arbitrator has already been appointed now by the Honorable High Court. Already appointed.
My lords,
Therefore, my lord, you
kindly
can
see-
consider, my lord, making that application there itself.
17.
My lords, kindly.
17. I think your lordships also have taken a view in Gujarat High Court, my lord, that 17 may be a better option
My
there.
lords, that may not be so. My lords, kindly see, in this matter, the IA was allowed. The respondents filed an
Yeah,
filed
is
an
there any
SLP.
interim station?
No, nothing.
And no issue letter. We will
Very well. I
consider
have no
once
objection.
the
My lords, in fact,
Nayantara
there is a
Learned Counsel-
direction by the Honorable
No
Supreme Court.
difficulty. You file your.
Very well.
Nayantara Learned Counsel for the appellant seek 4 weeks time to file the counter to the SOB. 4 weeks.
Grateful.
Shri Gyan Chinapal and senior counsel appears for the respondent. 4th,
Very well.
Very well.
Grateful.
Agreed.
he was also former advocate.
My lord, I appear for the appellant. My lord,
Yes, madam. Dispensation of production of WP copy.
my lord,
and
this
its
is a
annexes.
matter where Act 7 of 2014 is challenged. My lord, and there are a batch of, my lord, writ appeals that are pending before another coordinate bench. My lord, this appeal may be posted along with those appeals, my lord. There is a delay of 2,490 days.
2000.
In those
Disposal,
appeals also, there is a delay.
disposal of the matter was on the basis of the statement of learned advocate general. The same matter.
Yes. The pay scale of the assistant professors in a first year.
My lord, but.
Pay fixation.
Yes, my lord, but similar matters, my lord, may post it along with those. My lord, the financial implication is
But the
huge.
learned advocate general made a statement.
My lord, that also has been considered by my lords, the earlier bench, and my lord, all these matters are,
These probably have a connected matters or something. madam.
my lord, it is WA 2476 of 2015 and connected matters.
When they are going to be listed.
My lord, It's before the coordinate bench. I have no.
Roster bench, some other roster. ಇಲ್ಲ ಏಕೆ roster ಬಂದಿಲ್ಲ ಇದನ್ನ.
It's the.
Yes.
In respect of not writ appeal 2476 of
2015 matters.
a special bench headed by not Mr. Justice CH-1.
So then we will post this matter with administrative section. GA submits that the connected appeals are there in WA 24/76/2015. Before the coordinate bench of this. Full stop. For needful. Allowed, 2 weeks. Ad note ಮಾಡ್ಕೊಳ್ಳಿ, register judicial has to be informed to give the special orders.
You need to file the note for, you need to file a note to place before the Chief Justice on administrative side for clubbing the or.
My lord, it's only for clubbing. I didn't mean that it's for.
Because it has to go to other bench.
Yes,
You please
yes.
file a memo, madam.
File him. Within day or two, you file special.
Even in the register judicial, you please send the memo. This matter may be clubbed with that, then they will take the administrative order.
Blind.
I'm for the appellant in this matter, my lord. The short accommodation, I press 1 week, my lord, this matter. Today only I served the copy to the caveata.
Not yet, sir.
Yes, sir.
You are
I'm for the
fair
appellant.
asking time, sir. Preliminary hearing, you should argue.
Lord, I engaged a senior counsel. Personal inconvenience is there for today to appear senior in this matter. Any date may be fixed, my lord, next week.
You are for R1.
I am for R1. Copy is just now, sir. And the copy is just now, sir. I pray for 2 weeks' time and there is a connected writ appeal.
Number, please.
Writ appeal 741 of 23, man.
Who has filed that appeal?
That appeal is filed
One of
by
the
the
respondent,
mortgagee of the appellant herein.
one of the respondent in the writ petition.
Howdri, one of the respondent, number ಹೇಳ್ಬೇಕು. Please tell the, who is the rank of the respondent.
Respondent number 8
Yes.
in the writ petition, my lords.
Learned counsel for this. Wakalat filed by the caveator, Mr. Patil Virangauda Chandrasekhar for first respondent is accepted. Full stop. Learned counsel for the first respondent submitted that there is a connected appeal filed by the eighth respondent.
Yes.
In WA 741 of 2023. Post this appeal along with 741 of 20.
Grant 2 weeks' time after 2 weeks.
That's good.
Please notes for the appellant.
Appearing for the respondent number 4,
Connected
my
matter had come up. Your lordships are pleased to connect this petition, this appeal along with that. 1237 of 2023, my lord.
You are there.
My lord, I
The-
appear for the government.
The ban on the.
I appear
vehicles
for the
of
respondent number 4, my
4
lord.
years old.
4 and 6-year-old vehicles.
No registration for the vehicles which are 4 years old. Same.
No, that is the term of contract which I have challenged here, my lord, wherein the airport authority, that is BIAL, and the KSTDC under whom I am working, they have imposed this particular condition which is contrary to section 41(7) of the Motor Vehicles Act. Because under 41(7), your lordship will kindly see that it gives a vehicle a life of 15 years. And so far as these contract carriages are concerned, they have to get a fitness certificate under section 56. And there are already a format has been given under which I satisfy all the conditions. And so fitness certificate is given and that is, I am operating on that.
And objective of having a airport taxi from airport to here. We can't allow 15-year vehicle, all the vehicles.
No, I am not saying 15, my lord, but then.
Breakdown here and there and the vehicles going 100 kilometers. That is the purpose, no? Should
Your,
be objective should be understood.
I fully agree with your lordship, but then 59 says,
Right
who has
here,
to frame the
Bangalore
rules?
is a silicon city, you expect a foreigner from walking, travel in a 15-year
Lord,
old vehicle.
this is
with
meant
wear
for
and
air
tear and,
travelers, my lord.
flattened tires and everything.
My lord, this is all, we are maintaining the vehicles as per the standards prescribed under the act.
That depicts the reputation of the city.
No,
God.
my lord,
Yes.
I'll kindly see. 59 says,
You run the vehicle somewhere else, use
have-
for some other taxi
no,
and other things.
I have no difficulty about that.
Special
I have
purpose
no-
airport is established.
My lord, in nowhere in the world this condition is imposed. Nowhere in India this condition is imposed. I'm not saying.
Let it
You see,
start
there is
from
a-
here.
And then they have to do it. No, they have to do it. They have to do it in terms of what the law says. Law says that you can frame the rules. We are not qualm about that.
This is done under some statute or rules? or
No,
guidelines?
there are no.
There's a,
I'm sorry.
there's a
I'm
city
sorry.
statute scheme, my lords, which has been framed.
You have filed a counter
No, my lord, in an appeal, we don't.
of
file.
this appeal. There it was found filed.
There was no counter was filed.
We have filed a counter, my lords.
No.
I appear for the respondent number 4, BIL.
BIL has filed it, but government did not file it, my lord.
My lord, the list is.
Who filed the counter? Who filed?
Respondent number 4, my lords,
Respondent
BIL.
number 4, BIL has filed.
Respondent number 2, 4, and the appellants, my lord. The state is just
The
the.
counter was filed by the airport authority in the main proceeding.
Yes.
Yes, my lord.
Very good.
Counter I have produced, my lord.
Statement 142, statement of object.
My lord, page 142.
The agreement which is entered, I am not a party. It is between KSTDC and the BIL, number 2 and 4. And I am running the taxis under KSTDC's radio or internet services.
The concession agreement is between which party?
Yeah, between 2 and 4. This one number 2 is the KSTDC.
STDC and airport, Vice President, CIL. STDC and Managing Director.
Notice may have to be directed to KSTDC, my lord.
That is what we are asking. Which is the scheme? Which is that scheme?
My lord, the scheme, I'm sorry.
Scheme on the basis of which
My
the
lord, it was the
concession agreement is entered into and the conditions are incorporated.
Yes, that
Which is
was between, my lord, that scheme,
Where is that scheme?
the agreement.
Let me finally answer.
Madam, please go through page 22 of the.
Concessional agreement.
Yes.
That has been entered into between the Karnataka State, my lord, Tourism Development and Kempegowda International Airport Limited.
So that is on the basis of some scheme, parent scheme. Which is that scheme?
Page number 306, my lords.
Anybody is appearing on behalf of the airport authority?
I appear for the respondent number 4, my lords. It
You
appears
are-
I'm not
you are-
audible.
I agree. All right.
Your lordship will kindly see, my lord, I have produced it because they had filed it. At page 306, your lordship will get that scheme, which is called as a city taxi scheme and not airport taxi scheme. And there the limitation was within a radius of 25 kilometers we have to operate. And this Devanhalli airport is more than 25 kilometers from the city. And therefore, this is not applicable at all. But however, the learned single judge relies upon this. And there is no statutory
Airport
backing.
comes within the Bangalore city, sir.
No, that is why when airport taxi came up,
Comes under BBMP,
no, it doesn't come under BBMP.
city limits, airport.
City limits to hai? How?
Yeah.
No. Kindly see, my lord, page 307.
I'm sorry, my lord.
Iదే nodi, for the tax purpose, it has been done. I have read it somewhere.
My lord,
Please check it.
because your lordship will kindly see, it comes under Bangalore Rural District, Devanhalli.
No,
Bank-
we are not talking about the Devanahalli, sir. We are talking about the airport.
That is the airport at Devanhalli is more than 25 kilometers.
For the city, not for the river. Two not seven.
307, 307. It says the motor cabs or city taxis shall operate within 25 kilometers radius from the limits of the city corporation, my lord, within 25 kilometers. Therefore, even in 98, there was no extension because the airport started functioning only in 2008.
See, you are claiming the right under the agreement between the BAL and KSTDC.
True, my lord.
Whatever you have to work it out within the framework of that.
But
agreement.
that cannot be contrary to law. This is my submission. My submission is that it must be framed by the central government. The rules have to be framed under section 95 and 95 of the Motor Vehicles Act. We are not saying no, but the rules have to be properly framed by them for airport taxi system. And even if suppose it is to be made 6 years or 7 years, what we are saying is that let it be in terms of the rules. And today they will say 4 years, tomorrow they may say 3 years. We do not know. See, this cannot be left to the contractual because it is otherwise it becomes contrary to section 23 of the Contract Act.
Let us see. Our note, madam, verify it and make a proper statement.
Notice.
My lords, may I make a submission?
Yes.
My lords, there was a connected matter that was listed on 26th of Feb on last Monday.
That is why I submitted, my lord. It was connected
It
with
may
the
be connected with that
along-
matter, my lords, and
That
both
notice
may
also
be
has to be
taken up
given in
together,
that.
my lord.
It will coming on 26th.
No,
Please,
no,
my
it had
lords.
come up on 26th, my lord. Your lordships had clubbed this matter along with that. That is what my learned friend is saying. And therefore, this matter has come independent of it now. Now, if your lordships are directing notice in this, automatically that matter will have to be, notice has to be given in 1237 also.
Want to let them take notice here and.
Please, my
we will
lords.
take
Very
notice.
well, very well.
Let GA takes notice.
Lord, I think notice for response for 1, 3 and
1 and 3, my lord.
1 and 3.
And 2, I may be
STDC.
directed to serve on the,
Gururaj Joshi, my lord, for respondent number 2.
Shri Gururaj Joshi is directed to take notice to R2.
please, my lords.
Then BIML.
No, BIL, I have already served. They were caveators, my lord.
Pegoda.
I'm appearing for respondent
They are
number 4.
caveators, my lord. I have served them.
You are good time, sir. You give your appearance, so and so takes notice per R4.
R4.
Full stop. Both sides submit that they connected appeal in WA 1237 of 2023. Post this appeal along with 1237 of 23.
Please.
Okay. Four.
Obliged, my lords.
Four. We'll take it.
I'll take notice, my lord. I am grateful.
Yes, good done. Any words? Shri Municipal Learned Council for the
Junior.
petitioner. Learned GA text, madam.
My lord, for responses 1 and 2.
Text notice to 1 and 2, notice to 3 and 4.
The complainant in this matter.
Lord, in this matter, state preferred a writ appeal in 1526 of 2023.
Yenaಗಿದೆ sir, what happened, the fate of that writ pending?
Lord, it is pending.
It is
Lord.
pending.
This may be.
Compliance has not been done in that matter. There is no order. of
You
state.
are not paying a remuneration to a member of, ex-member of a minority commission taking his services. Learned GA takes notice to the R3. Here, pro forma respondent.
Yes.
Full stop. Learned GA submit that the state has already filed the writ petition, writ appeal in 1526 of 2023. Full stop. Hence post this contempt along with writ appeal 1526 of 23.
But my lord,
Date ಕೊಟ್ಟಿದ್ದಾರೆ ಅದಕ್ಕೆ
no compliance has been done in that matter. The office objections have also not been compliant.
It come along with will.
One more writ appeal, impugned order is
Connected grade pay regarding,
writ appeal 171 of 2024. my lord. One more writ appeal has been filed.
which date it has gone, sir?
It has not yet listed, only this matter is listed. Both matters may be listed together.
Learned
171 writ appeal of
Learned
2024.
Council for the appellant submit that union has filed another writ appeal in writ appeal 171 of 2024. Post this appeal along with 171 of 24.
I'll serve a copy of that.
Full stop. Wakalat of MS Parsarthi for the claimant first respondent is accepted.
MS Parsarthi and MP Shikha.
First the copies.
Please, sir.
Council for the appellant to furnish one set of copy to the council for the first respondent.
Please.
And for the appellant in this case, not sought for any stay. Not my lord, the issue is, my lord.
Can't settle your rights in the civil court and go
No,
to the BDA and seek for compensation.
No, my
That's what the order of the learned single judge.
Yes, but in this case. Yes, my lord. Kindly see the prayer of the writ petition, my lord. Your prayer is, my lord, seeking Mandamus to consider my representation.
Yes.
My lord, and my lord, the documents available in the writ petition, the submission was made by the learned counsel for the BDA is contrary to the documents available in the records, my lord.
Can a writ court decide the title of your title?
No, no, my lord, I'm
Then you
seeking.
go, that's rightly.
No, my
the
lord,
writ
I'm
court
not
that
seeking, I'm not
you
seeking.
obtain your title issue, resolve your title issue.
No, my lord,
before
I'm
the
not
civil
seeking.
court and take the compensation.
No, no, my lord, I'm not seeking any declaratory relief in the writ petition, my lord. The relief sought in the writ petition is very simple. I have filed submitted a representation
Who
that
has
was
to
not
pay
at all considered.
compensation to you, sir?
My
Who
lord.
has to pay? BDA.
Yes, my lord.
BDA saying you are not the owner,
No,
land belongs to the government.
But my lord, in the acquisition notification, my name is there, my lord. My lord, senior counsel.
See, let the learned senior council make.
But BDA orally says, my lords, before the court that I am not the owner. 4161 contains my name. The special task force had conducted an inquiry to know whether there were grant certificates and other records in it. They also recommend this special task force of BDA, but no award or not compensation is paid. At a notice period, statement is made, I am not my title is disputed. Records show otherwise.
The statement is made, what you are repeated before the Honorable Single Judge, sir.
My lords,
Para number 2, what is the answer before the learned Single Judge?
my lords, it is not even considered. My lords, it was only for a mandamus to consider my representation.
Made available to the petitioner, not the owner of the.
No, my lords, the
Rise of that you want to decide your title.
not, I am not deciding my title. My lords, I am only saying this.
You go, we'll permit you to go with learner single.
My lords, I'll take that leave, my lords, but before that, can I, my lords, pursue your lordship? Section 4.1 notification, I mean 17, preliminary notification 19.
Notification is made in your name.
My
At the
name.
time of making award, they are now claiming that it is a government land.
There,
award
there
can
is
be
no,
passed.
my lords, there is not even an order passed. If your lordship kindly sees page 156, the special task force of the BDA says, yes, this man is the owner. We have verified all the documents. They are the owners. On that I come here. The BDA council on a oral statement simply says, my lords, I am not the owner.
So
There
far
should be
as the
that.
statement is concerned, order is concerned, there is no error. How could a appellate court, the
My lords,
report,
I am only saying,
we are exercising same jurisdiction.
my lords, at least they should
Not
file
the
some.
appellate court to the
My
learned single.
lords, there should be an order at least that, my lords, denying it.
A review there, sir, because your statement is not recorded here. That's the
Abs-
one point.
So in course,
Para number 2,
Then, my lords, permit me to, my lords,
in course of the
seek
submission-
review
in
instead
course
of.
of the submissions, learned senior recruit, Mr. So and so, assisted by learned so and so, seeks permission to withdraw the present writ appeal, stating that the appellant petitioner would opt to file a review application before learned single judge. Full stop. The permission to withdraw the appeal is granted. Liberty is reserved. You to approve learned single judge with approved proceedings. However, about the merits of which this court does not
Please.
express an opinion.
before filing appeal, ನಿಮ್ಮನ್ನ ಕನ್ಸಲ್ಟ್ ಮಾಡಿದ್ರೆ ಸೇಮ್ ಅಡ್ವೈಸ್ ಕೊಡ್ತಾ ಇದ್ರು.
Dismissed according.
Obliged.
Not appear for the appellant.
One we have to dismiss. Here the very simple case. Here the government has made 11 E schemes.
Comment number 1, Malad had presented a sale deed since the sale deed.
Only one question, madam. Whether the orders in the writ petition 117177 of 19, para 7 of the order,
Malad,
whether these writs, the state challenged these orders.
Malad, aggrieved against these orders, Malad, the state has preferred an appeal before the Honorable Supreme Court. Malad, and there a stay order has been granted, Malad. So considering that, Malad, I will produce those orders on the next date of hearing. Malad, with regard to those SLPs, Malad, where the stay order has been granted. Against the orders of the coordinate bench, where the learned single judge has relied on those orders. My lord, those are in appeal before the Honorable Supreme Court and there's a stay order that has been granted. My lord should grant me 2 weeks
In
time.
this- This case of Vaishali stay order is granted.
Yes,
Where is?
my lord, I'll get it, my lord, but my lord may grant me 2 weeks time, my lord, I'll get the order, though I have, but I do not know whether it is this thing. I'll produce those orders.
Yes,
sir.
we have not heard so far.
No, my
Now
lord. they have
all the
not-
sub-registrars are not insisting 11 E sketch when the parties produce this judgment.
Yes. my lord is right, but we have preferred, my lord,
Created a
petitions
chaos.
before the Honorable Supreme Court. My lord, where the matters have been stayed.
Only a sketch of the
So
revenue
it is
service.
it is about not
It
substantive
required.
information. They can be. You can't.
Could
if
I
you-
seek for 2 weeks time, my lord, I'll produce those orders and I'll leave
They
it
are
to my lord.
dedicating all the parties to the revenue department. Now it became a menace. Again, code it, give us the like, same, see also the same.
You can get the order of Supreme Court if passed within.
My lord, I'll place before my lord those orders and then I'll leave it to my lord to pass the orders. My lord, I will
Okay.
not come in the way. My lord may grant
Learned
2
GS
weeks time.
submits that regarding 11E sketch.
11E sketch.
In Vaishali's case, in
mandatory-
WPL 117177 of 2019, state has prepared the SLP before the Honorable Apex Court to furnish the copy of details of those things. Details of the same, 2 weeks.
Like,
In this, Lord, there are two subsequent developments. But original acquisition is for setting up of a sewage treatment plant. Now, Lord, the authority now says that since this land has now come under the urban agglomeration near a residential colony, setting up of the plant would be unviable. Secondly, my Lord, the PWSSP now at page 139 gives an endorsement that there are no funds to set up this plant, but this is only subsequent ground, Lord, which Lordship may kindly consider. Page 139. Let's go sit down. Don't sit. But may I request Lordships to kindly see page 139, not second paragraph. The first paragraph itself. Due to the fact, Lordships, due to the fact that there is no budget in the budget related to the said project in this board, and the reason that there is no fund to construct, that word should be sewage, not dirty. Sewage water treatments unit in Vijayapura town, drainages as the works have been completed. There is currently no opportunity to construct such a project. Now, Bayapa also, my lords, has given an endorsement, which is the town planning authority. There is some mistake in the English translation.
Implementation thereof. These people are.
There is a delay of about 300 days.
Ranga, notice, put.
Please.
GA takes notice to R1 to R3. So urban water supply, who is appearing, sir?
Lords, we will serve upon the council who appear before the
Notice
learned
to
judge.
R4 and R5, and sir, and summons also permitted.
Please. Lordships may, but in addition, permit me to serve on the learned councils who appear before the
Yes,
single.
summons permitted and service to the learned council appearing the writ also.
I appear for the second respondent.
not the prayer in this petition may be.
Getting experienced both for the AS and IPS.
In 88 Supreme Court till that I'll pass on the judgment.
Okay, good.
With the regard to maintainability of the PIL in a service matter, my lord.
Service matter, PL not maintenance.
Not maintained. That is right from 1988 Supreme Court to the latest
Your lordship
judgment.
may kindly say it's not mere pertaining to the service itself, my lord. It is a question of,
Even otherwise, the nature of.
your
the-
lordship may kindly say it's a question of loss to the exchequer of the state.
Even if it is not to be perceived. as
We are
service
not
matter,
individually, we are not
Kindly-
question.
Kindly listen. even if it not to be perceived as a service matter in stricto sensu. The nature of the prayer doesn't permit the court to.
We'll amend the prayer, your lordship may kindly.
That the
Your
latest
your
judgment.
lordship may kindly see. We are not particular about a particular officer or a particular post. Our grievance before your lordship is the last to the exchequer as per the arbitrarily appointing the ex-cadre officials contrary to the central rules. Beyond the scope, in fact, it is contrary to the Indian Administrative Service regulations and cadre rules. Your lordship may kindly see the rules permitting them to appoint ex-cadre post to the extent of 40. But the state government has appointed 129 posts. And your lordship may kindly see page 44, your lordship may kindly see. 38, page 38, annexure B, your lordship may kindly see.
Ian, prayer amendment, sir, what is the prayer amendment you, sir?
To make appointments. That the petitioner cannot say how, I'm sorry.
Let them appoint the officers as per the cadre rules and IAS service regulations.
Support the court, monitor and.
Gopal Swami.
Senior advocate, senior advocate. Former
Sorry,
chairman of the bar.
not inclined. Indeed not inclined to entertain such kind of prayers. Third learned senior advocate Mr. Gopal Swami, assisted by learned advocate Mr. Bhargav G.
Son.
For the petitioner and learned
DSG, Shanti Bhushan,
For the.
for
union-
second
union
respond.
for Union of India.
And
Post of the
DA for the state.
also learned and also as well as learned government leader, government leader. Yes, madam, what is your good name?
Nilufar Akbar.
Nilufar Akbar.
Nilu, full stop. The petitioner claims to be representing the state government employees. He further claims to be a very public spirited person. The grievance is about arbitrary appointment, alleged arbitrary appointment made by the respondent state to the cadre post of administrative service.
Cadre and ex-cadre post. Cadre and
Cadre and
ex-cadre.
Ex-cadre post, government service, full stop. The present petition paragraph is brought in the nature and style of public interest litigation, advancing the following prayers. And court prayer at page 22, 1, 2, 4, 3. The first prayer, as could be seen is to direct the respondent to act in accordance with the Indian Administrative Service and Duplicate Cadre Rules 1954 in the interest of justice. Full stop. This prayer is too vague to be countenanced. Full stop. There is no gainsaying that the respondents would abide by the service cadre rules in making appointments. The second prayer paragraph requires the respondents to make appointments to the post of cadre officials in accordance with the very rules. Full stop. Again, this prayer is to be attended by the authorities. There is nothing to indicate that the authorities would not depart in their conduct from observing the said rules in making appointments. The third prayer is relating to poor and in respect of all the AS, what is administrative
service.
What is AIS?
Indian Administrative.
Indian,
Service.
no,
All India
Service.
All
India
Service.
All India
All India
Service.
Service Officers, whose appointments become illegal by virtue of the restrictions in the laws. Full stop. This prayer is also too omnibus to be considered. the outweighing aspect which renders this public interest litigation is that the prayers travel in the realm of service. Full stop. It is right that the public interest litigation will not be maintainable in relation to service matters. In Dr. Duryodhan, Sahu, and others versus Jitendra Kumar Misra, into 1998, 7 SCC 273, the Supreme Court has in terms held that in service area, the petition, the nature of public interest litigation will not be maintainable. It was even held that petition filed seeking writ of quo warranto in respect of the appellant as in respect of appointment of the appellant lecturer before the Supreme Court with a prayer to post the order creating the post itself and to prevent the authorities from appointing the appellant as lecturer was not maintainable. For all efforts, for all the above considerations, the court is not inclined to entertain the present petition. The same is dismissed.
Great.
My lords, I seek for a Passover, my lords. I seek for a Passover, my lord. Seniors on his legs in another court.
What is it about?
This is admission regarding memorandum of understanding and joint development agreement. Arbitration award is for the arbitration. Arbitrator rejected the claim of and only the ordered for refund of 5 crore with 8. Arbitration suit 34 is dismissed now. Sharma.
Yes, ma'am.
You take notice.
There are
Please.
already appeared, please.
Learned advocate Mr. R. L. Sharma appearing for the respondent on caveat.
Please, ma'am.
Accepts the notice.
Wakalat accept.
Wakalat is filed.
Please.
Wakalat is already filed.
Yes, ma'am.
May I make a request, my lords?
Caveat are
Listed after 2 weeks.
My lords, the difficulty is, my lords, the matter is listed on Tuesday, my lords, before trial court. It's a commercial dispute. Commercial court, my lords, is proceeding with the matter, my lords. Let them not precipitate with
No,
the
no,
matter,
there is,
my lords.
now they filed an application for orders and rule away.
My
I have to file objection to that.
You file there.
Please,
Let their
nothing will happen
objection,
because they filed an application for, they are protracting the proceedings. Now they filed application
Well,
orders. After rejection of this
Okay,
application,
there you come for final hearing, we'll hear it and finish it.
My lords,
Close the
fix a
matter.
date in next week, my lords. Any date next week, my lords.
Not next week,
2
12.
weeks.
12.
Next week,
Great.
allows
12th.
dates are not there.
12th.
Great.
12 to. Yes.
That's,
This
matter.
petition become infructuous by virtue of the subsequent notification.
They have filed a reply, and, saying that they have taken appropriate steps for disposal of the ash. Not I am.
Then if it is complied, we withdraw the writ, sir. Now they are, now it
I'm
become
satisfied with the
infructuous,
reply,
now
Lord.
the statement of the learned GA.
Yes,
Shall we close?
close more.
Full stop. Learned GA submits that the purpose of the writ has been served under the.
That's
It become infructuous by virtue of the subsequent notification issued in the year 21.
For virtue of
The subsequent notification issued in the year
notification issued in the year
2021.
2021. That's full stop. Learned Council CPS Malipatil is not repeating any of the submissions. Petition is closed as infructuous.
Petitioners, my lord, kindly seeking for a short accommodation. We are yet to receive instructions from the clients.
This also become infructuous. There are several writ petitions they have filed subsequently also, my lord. And one writ petition was withdrawn by the petitioner.
Kindly praying for a short accommodation, my lord. We are yet to receive instructions from the clients.
Full stop. Or client instruction. Learned GA submit that the writ petition become infructuous. Learned Council for the petitioner seeks accommodation to complete the instructions. Next week.
Next week.
Next week. No, the infructuous anta now GA is submitting, you verify and withdraw the writ.
I will come back with
You
instructions.
complete your instruction with your client.
All kind of.
Please, my lords. Petitioner. Yes. Petitioner had applied for the grant of a quarry lease way back in the year 2005, my lord.
Quarrying lease, sir. Quarry.
Yes, my lords. An application is produced at Annexure A, my lords. Over an area of 2 acres to extract ordinary building stones in the Gomar land, which came to be
Lord, subsequent to filing of this writ petition on 23/2023, the application of the petitioner came to be rejected by the competent authority.
On 23.
20th March 2023.
What happened?
The application of the petitioner came to be rejected.
23/3/23.
Yes.
it has been rejected way back in the year 2008. Now subsequently, I am not served with a copy of such order, my lords.
Then you serve the copy, new cause of action will come for police sir and they will file a fresh writ.
Herein, my lords,
This has been
based
issued
on
to
the-
him. This has been issued to him, to the petitioner.
ಜಾರಿ ಆಗಿಲ್ಲ. ಇಲ್ಲ.
I'll see that.
Yesterday night only I contacted the client.
No, I'll serve one more copy.
No, but that's because it is posted for final hearing, my lords. I will be submitting.
Because in the year 2018, we have filed statement of objections. I'm not, since this petition was, this application was pending, it was rejected in the year 2023.
So revising authority's order is there, it is produced as Annexure B. Pursuant to that order, my application should be processed and I must be granted a query lease because revenue NOC, forest NOC and technical reports are already obtained.
Now there is subsequent development, they have rejected it.
So that is impermissible to be passed because
You can challenge it, nobody prevents you, but not, it's pressed all of it. Why should we continue?
Please examine it, sir.
And the query lease has been executed to the respondent herein, private respondent, subsequent to the rejection of his application.
Lease executed. What is done subsequent to?
Subsequent to the rejection of the application of the petitioner.
Then it is
This
holding on.
application is rejected,
my submission would be, after the order of the revising authority, when my revision petition has been allowed and holding that I am entitled for the grant of query lease because I am the first applicant.
Both of them.
Now your application is rejected and quarrying lease is granted in favor of the sixth respondent. Now this is the statement of
Such an
government.
oral observations at the fag end, my lords, may not be in the good taste, my lords. I cannot be taken by surprise when the matter is posted for final hearing.
In court of law, we have no taste.
That he was heard before the competent authority, both the sixth respondent as well as the petitioner. Thereafter, this order was passed. He is well aware of the order.
Because
Now he cannot make such submission before
Oh, the lease deed is executed.
order is in my favor. Revising authorities order is in my favor, and moreover that
Court of-
impleading respondent has filed the statement of objections. Therein he has never contended that the lease deed has been executed in his favor.
Naturally, he will file the counter to protect his interest. We are helpless, but you are not helpless. You can.
Sorry,
file a
my
fresh
lords.
suit.
Sorry, my lords. I'm not.
You can file a fresh lawsuit.
I'm not on that, my lords. I have filed the writ petition. It was contended that the matter is pending before the Honorable Apex Court. Honorable Apex Court has already dismissed the contention. And now thereafter also, if the department proceeds to execute the query lease deed in favor of the respondent who is a subsequent query lease applicant, which is highly impermissible, it is opposed to erstwhile Rule 23. And also decision delivered by this Honorable Court deported in 2021, my lords. It appears to be playing fraud on the not only the parties but also on the.
No, you are a party before the competent authority, sir. That's what kept in mind. But your party may not have instructed you. Please verify.
All right, I will be verifying, but the manner in which we are taken for a ride before this Honorable Court appears to be little hurting our
No,
sentiments.
they are not taking the court as ride or court is taking you to on a ride. See, they are making a submission that before a competent authority, in your presence, some order has been passed and a quarrying lease was granted to the sixth respondent. They are making a responsible statement. You please examine it.
No, if that is produced before the Honorable Court previously, my lords, we would have checked that. I have nothing against that.
No, we are not found fault. Now they are making a submission. Now we are requesting you to examine and come. That's all.
Sorry, I don't want to be requested, my lord. Sorry, my lord.
Tuesday.
But of course, I will verify and come back, my lords.
Tuesday.
Any date, my lord.
Tuesday, this Tuesday.
Yes. Stop. Learned
I
GS
shall
submits that
place
there is
all
a
this
subsequent-
material
there is
with
a
the memo.
subsequent development
Do
taken
it.
place. And the application of the petitioner has been rejected and quarrying lease was granted in favor of. the-
I may be served a copy.
And furnish the copy of the order to the learned counsel for the petitioner also. Full stop. Equally learned counsel for the petitioner seek time to examine and come back. Tuesday.
Obliged.
Please, my lord.
appear for the petitioner. This is a matter in which a student.
Appear for respondent number 3 and 4, my lord. Pray
Student
for a
was-
short accommodation.
My lord, this has
Respondent
been going on for What is the several. issue, sir? What is the matter?
Matter is of refund of the admission fee which was paid to the
Yes.
respondent.
R3 and R4, ಯಾವ college ಅಲ್ಲಿ last time it was heard.
ಹೌದು.
Time.
Devraj
Rajarsu Medical Academy of that Kolara,
Kolar, yes.
the medical student, they are seeking refund of excess fee paid by the. The same.
Hospitalized, my lord. Kindly have it next week, my lord. Refund of-
Excess fee here in the medical college, they will take. The candidate is put inside mistake. They will do it. They will pay. Now they are coming and asking for the direct.
Years back, stating that, virtually stating that they are entitled to the refund based on the facts. Their whole case is that the last day for admission was on the 30th of August.
2007.
Last date was indeed extended till the 7th. So their case is that they could not have made admission because they would have lost the seat. And therefore, they are not returning the fees. That falls because the date was extended by the DGHS by 7 days, only to fill up vacancies.
That
Second fact
submission
would
was
be whether
made by.
They've not come forth to the court to explain or say about this fact, nor say whether they had actually admitted or not pursuant to that extension. The fact that there was an extension was enough for the purpose of the petition. But neither have they mentioned about the extension nor about whether they admitted anybody. Only when we filed a memo on behalf of the NMC that this aspect has come to light. Otherwise, their whole case in their affidavit is that the last day was over on the day on which you asked for return of the fees and you wanted to discontinue, and therefore we could not admit anybody. That's all the case.
Same, because order sheet says you are only taking adjournment. See, Mr. G1,
Please,
last time you are taken, before that Bipin Hegde.
From 22, my lord. From 27/5
Karnataka Learned Council for the petitioner is present, and also Sri N. Keti Council for the MCA and the GA for the state. For the R3 and R4, Mr. G1 Alani.
Please, my lord.
He is again seeking the time. And council for R3 and R4 regularly seeking adjournment, which is not in good taste. You come forward with proper solution
Next week, my lord. Kindly have it.
next week, because next week, stand over to next week, one date Kodi, tribal. They pay huge money and these people, medical college. Can't take it.
he joined some other institution.
Council supposed to, and they. These people, they are not doing. If we don't do it, we will directly pay. Because next year council, they will collect the money on behalf of this college. We will ask the on their behalf. Without so much of money and.
Here KEA will not come into play. They
No.
obfuscate
For
that
the
by
money
putting- by-
that is to be paid to the petitioner, what we are thinking of. We'll direct the KEA, whatever the money due from KEA to the medical college, will deduct it and rest will be paid.
Yes, from the others, but. no,
From
there'll be
other.
No, my lord, there'll be an issue there. This is a deemed university. And deemed universities, they pay their fees to the DGHS. The counseling is
But
not
state
conducted by
seat, for
KEA.
the state seats,
They have obfuscated that in their statement of objection by going on the track that KEA is the authority for them. And KEA's last date was 30th, and therefore we could not. That was that's why my lord is speaking about KEA. But KEA is not the authority, DGHS. A direction then
then
ensue.
we'll give the DGHS only. Yes.
Please.
I think, my lord, they will pay once the matter gets disposed of. It's because it's been,
Now they are only taking time, gaining time.
that's the only reason.
Obliged.
Obliged.
For the appellant.
Appear for the first.
My lord, this is pertaining to the, my lord, the appointment of the backlog vacancy of one post. The respondent herein, my lord, at the time of the application itself is the overaged, my lord. The, my lord,
Give the some facts, sir.
yes, my lord, the page 56, my lord, the 56, the appellant, my lord, the issued the paper notification inviting application for the post, my lord, page 56, my lord. Seven, my lord, there is the my lord, date commencement date is, my lord, 19/3/2018, my lord, for filing application. And last date for filing application is 31/3/2018, my lord. My lord, the last sentence, my lord, for further information, candidate may be log in website so and so, my lord. It was, my lord, page 88, the that notification, my lord, page 88, my lord, it's Kannada, and page 90, my lord, it start in the translation, my lord.
Now, this is the post of first division assistant.
Yes, my lord. First division assistant. Page and 90, it is English translation, relevant page, my lord, page 91, my lord. Page 91, my lord. The first division assistant possesses any degree, BA become BSc or equivalent degree in any subject from the UGC approved and recognized university, submit 3 years marks card and convocation certificate duly attested by the Gazette officer. Studied Kannada as first language in SSL examination. Certificate regarding the passing of data entry operator courses from the institute recognized by the government. This is the requirement. My lord, the general other conditions, my lord, it is in page 93, my lord. Lord, 93, page 9. First condition, as on the date of submission of the application, the candidate should attain the age of 18 years and should not be above 40 years. And third condition, my lord, is produce the marks card and birth certificate duly attested by the gazetted officer. My lord, condition 6 says, my lord, that the filing, the application commences from the 2018 and last date filing for 31/10/2018, my lord. My lord, page, kindly come to page 60, my lord. 60, my lord. The typed copy is in page 61, my lord. Lord, 61 typed copy, my lord. And there the date of birth of the petition is 14/3/1978. Well, the date of birth of is the 14/3/1978. Even as on the commencement date of the filing, the application is on 19/3/2018 itself is aged about, my lord, above the 40 years.
On the last date of the application.
Yeah, no, in the date itself is above the age, my lord.
Commencement date,
Yes, my lord, on 19/3/2008 is the commencement date,
above 40.
above 40. My lord, there are, for this particular post, my lord, there are 208 applications we are received, my lord. My lord, the page 95, my lord, we have constituted the committee to scrutinize this application, my lord. Committee consisting of page 95, my lord, the committee was constituted for the scrutiny of these applications received from all the application, my lord. My lord, they submitted the report, my lord, it is page 95, translation is at page, comments from page
Scrutiny committee report.
101, yes, committee report, 101, it comments 101. My lord, the 102, my lord, the first division post is concerned, 102, my lord, the details all categories is as under.
Total, how many applications, sir?
208, my lord.
208.
Yes, ma'am. Other applicants, my lord, are not approached the court, only the first dependent is only challenging that order. My lord, the serial number 1 in page 102, the first division assistant post schedule online applications received within the stipulated time is 208. Out of that, as per the government notification dated 21/11/2011, the application of the candidate aged about 29 to 40 is listed annexure A. Application to the aged 18 years to 28 years is listed at Annexure B. Application to other than scheduled class candidate are listed at Annexure C. No eligible candidates in Annexure A is list who filed the complete application through online. My lord, no eligible candidates even in the B list who filed the complete application through online. Since no candidate who fulfill all the prescribed condition is available for the remaining one backlog SC FDA post, it may be re-notified after 1 year. My lord, the committee also scrutinized, my lord, the applications filed by the petitioner as well as others in the online. At page 72, my lord, the list is available, page 72, my lord. My lord, serial number 2 is pertaining to the first respondent herein.
It's Uday Kumar KP.
Yes, my lord. His date of birth is 14/3/1978. And he, my lord, he produced the SLC mask card. Yes, in the application, he produced the SLC mask. Data entry operating certificate, he has not produced the certificate from the recognized university. And he caste certificate he has produced. Degree mask card he has not produced in the online. This way, my lord, they have scrutinized. Now, my lord, my lord, page 79, my lord, the petitioner in the writ petition produced, stating that 79, my lord, Annexure H, my lord. They stating that it is the data entry operating certificate. It is issued by, my lord, on outsourcing service private limited. It is not by the the approved institution, government approved. It is only by the outsourcing contractor has issued the.
No, that is produced to show that I am working in BDA only as this thing and through outsourcing. Certificate is at Annexure E, my lords. 64.
He's not the BDA employee, my lord, he's out and the
The
contract, he's
outsourcing.
working under the contractor.
I
To
working
show
with
that
the-
I have been working at
Page 60.
64 only, that is the certificate which I have produced, Karnataka State Electronics Development Corporation Limited.
Deployed from Phoenix.
No, what
Yeah.
I, before, my lords, if I may be permitted to tell a few things. Here, what had happened, 208, as said by my learned friend, they have rejected all the applications. For one backlog vacancy, they say all 208 were defective. They had not produced one or two documents. Then the court came to know that we will direct you to redo the list, because how can all the candidates not produce any document?
My lord, that
There might be some problem with your portal or some through this thing. So I'll direct. Then they took up a stand. They had not rejected on the ground of age and all that. Then they said, no, before though he was within the age limit as on the, then the learned single judge had to go through that also. And because of the SC/ST Act rules framed under the SC/ST backlog vacancies, the finding was given that he would be eligible as on the date. And then what is the direction, my lords? Your lordship may finally see the directions, my lord. Your lordship may kindly see what the learned single judge has done. He has only directed to reconsider all the applications. Para 16 and 17, that is all, man. As stated, when all the candidates who had applied for the post had not produced or uploaded one or the other document, it would have been fair and reasonable on the part of respondent that it had given to all the candidates produced.
Page 31, my
If
lord.
an opportunity was provided to all the candidates, no complaint or violation could be made on the other hand. I deem it appropriate to direct BDA to offer an opportunity to all the candidates to produce the relevant document. It has not directed that I should be given appointment or any such thing. Only a Mandamus is issued to consider or reconsider, because there will be a doubt. 208 applications, that too for filling up one backlog vacancy.
For Bangalore Development Authority.
Yes.
BDA, Bangalore Development Authority.
So what is wrong with the?
My lord, here the petitioner, only one person has questioned my lord,
because
appointment, one minute. My lord, the petitioner itself is, my lord, even.
Protection are only in the nature of re-verification of the.
Yes.
My lord, no, my lord, it will.
Even after re-verification, if you found
no, my
not
lord.
ineligible, you do.
No, my lord,
process what is there.
it is question of not my lord, we have to conduct once again, it will the costly. It will cost my lord, the public exchequer. Here, my lord, even kindly.
And going for fresh notification and everything, it will cost you more, sir.
Yes, that is why, my lord, we have in the order said, my lord, it was called in the next.
The learned single judge has rightly put it.
No, my lord, we in the order itself, we have said, my lord, this post will called in the next notification.
Why you want to waste some more money?
My lord, because now we have to conduct the entire 208 persons, even though they have not questioned.
The scrutiny of again 208, allow them to submit physically and they do the process.
No, my lord,
They are all, somebody are working in outsource.
My lord,
Them already aged.
My lord, even the
2018, even after 6 years, you are unable to appoint one FDA belonging to backlog.
My lord,
even in the previous,
According to this notification.
even the previous notification, they said.
Appointing a one FDA, you are wasting so much of energy of the court and yourself.
My lord, even my lord, the petitioner, writ petitioner, my lord, he is even.
You being a public entity and a part of the government should be a model employer. The learned single judge has given an option. Allow them to submit physically also. 208, what is there? Within half an hour, we can do it.
No, my lord, the direction, my lord, that we have to issue them and once again, they have to receive all the application and we have to constitute one more committee.
Open your portal, ask them to give them the SMS, email, everything.
My lord, those persons are not agreed, my lord, they have not come before the committee. Even the.
You see, even in the High Court also, we are doing the same. We are the model employer. You take it as granted. Not a single appointment is questioned in the court of law. I will give you the example. All the appointments made by the KPSC and the government has been challenged before our court.
My lord, even if it is
Our
my lord,
registrars giving consultancy, free consultancy service to the government agencies.
my lord, even it is the redone, my lord, the petitioner is not
That
benefited, my lord.
fairness should be there, sir, something behind it. When High Court can do it, why can't you BDA can't do that?
In fact, even in the previous notification of 2011,
Since nobody comes, even a small request will be placed before the Honorable Chief Justice say, yes, give the opportunity.
My lord, even
When you are fair, no question of, nobody will.
my lord,
if you
even it is, my
think
lord,
behind the back.
my lord,
Yeah,
even
that interest is there. You want to carry forward and to bring someone.
no, my lord, even it was, my lord, the redone, my lord, the petitioner will not get any benefit because he is overaged as on the date of the filing the
See, after
application
scrutiny,
itself.
sir, if you come to the conclusion he is overage, don't consider his case. If somebody is eligible, you appoint them. Are you asking you to?
no,
your own
the
appointment, sir?
direction is also for the
No,
consultant.
he is challenging his rejection,
Yeah,
not
he
for
has
the others.
ignited the thing and we have to take in overall picture. You do on BDA peoples, you do for even allotment of site, alternate site. This is the problem.
Like this, in 2011, one notification was issued, my lords. One same post, backlog FDA.
Don't want to appoint a black person, black.
They are also the.
Arjan.
No, no, my lord, we have also in the consideration committee also said, my lord, it was notified in the next notification and for that post.
Where is the, show me the, any resolution by the committee that an opportunity is to be given to all to update the, any lacunas or cure the defect. Even we are also giving in all your appeals, everything we are giving years together, cure the defects. If BDA stand is to be taken here, 80% of the appeals or petitions filed before the High Court has to be dismissed.
Your own stand was that many of them have not uploaded. Might not have uploaded.
Technical issues are there. Online is, there will be, we also facing the technical problems will be there. Networking, some software not working.
This is only streamlining your record and nothing more. So why should you be apprehensive or objecting to such direction? And that too as an authority. With what cost for filing such a writ appeal?
The privilege appeal, writ appeal. We should.
As an authority, you must be reasonable.
But
if you are not reasonable, then the court will make it reasonable.
my lord,
What
only the
cost?
things we
Because
have to incur the public money, my lord, it will incur also.
No, at the cost of the public money, you are litigating here, sir. You are not litigating at the purse of the commissioner or chairman of BDA. You are litigating at our cost. We are also taxpayers. No, they are.
Since 2018, the process is not finalized because of this litigation.
No, they say that all the 208 applications are rejected because there was, it was found defective.
My lord, that the list
How
is,
can that happen? That is why learned single judge got a doubt, because in 2011 notification also,
Same.
all applications were rejected, they were defective.
no, this is
From
my lord, that
13
the
years,
online application received by the, my lord, the concerned online, the software engineer, they have thereafter the, my lord, they will forward to the,
By the officer.
not,
By the
my lord, this is not by officers, my lord, it was the committee was constituted by the, including the commissioner and.
One of the committee pay promise.
And my lord, my lord, the list of the applications were received by the software department, my lord. From that, they will then hand over the BDA, my lord. This is the list from.
Year 2018, 2011, we were also developed the software.
Yes, now it is developed.
Bugs were there, we.
Now it is developed. My lord.
Then you do redo, sir, no concession. I request the Honorable Chief Justice to impose heavy cost payable by the officers from his purse.
We are saying that.
my lord, the
Then you,
You are holding a one post belonging to SC person. That is the apprehension.
no, my lord, we have said, my lord.
you, either you show your better wisdom, or we make ourselves wise by imposing cost. What? To withdraw the appeal and,
No, my lord.
Mr. Krishna is very fair advocate for the BD.
No, for withdrawal, my lord, the lordship in the.
We'll pass, dismiss it without.
dismiss with cost of $25.
They will pay for it.
The other persons are not come before me, only petition, he is not there also.
ಸಾಹೇಬ್ರೀಗ 25,000 ಹೇಳಿದಾರೆ.
Madam.
ಜಾಸ್ತಿ ಮಾತಾಡದೆಟ್ಟಿಗೆ ಮಲ್ಟಿಪ್ಲೈಡ್ ಬೈ 25 ಹೇಳಿ 50, 50 ಹೇಳಿ 100. 100.
My lord, I request cost may be waived. my lord.
You pay to the High Court Legal Services Committee, sir.
I
PDA has
request, my lord,
enough
cost may
funds.
be waived in this case, my lord.
Without let them complete the process of these things within 3 months.
That may be direct, but cost is concerned, my lord. May be kindly.
We will not impose the cost, but it is dismissed.
And you should complete that process within 3 months.
We'll pass the order.
We have to issue the notice, my lord, some.
You have a phone numbers, SMS service, email
No,
service.
their phone numbers are not, because
The publication. 4 months,
all the phone numbers of all they are not available, my lord, that is the.
You
their
give one
patient.
notification, sir.
Yes.
You put it in your website, video website, you give a scroll.
If that is observation, my lord, we can individual observe.
Dismissed. So,
What is the nature of consent? First,
first division assistant. They will clerical. They are below the cadre of C post.
The Lord appear for respondent.
But in this 39, which is
Then I appear for petitioner. I seek for short accommodation, my lord, due to some personal inconvenience, my lord.
it's
One
Let's have
applicant
got-
has filed.
moved it.
one submission to make.
ಹೇಳಿ ಗುರುಮಠ. Sir, the senior advocate.
Because the petitioners themselves have referred to the fact that the census was completed on 5/5/2015. It has almost been lying for more than 9 years. There is no urgency. I don't, my lord, I will not object for them to take time. But my lord, after 9 years, yesterday evening, the report was submitted to the government of Karnataka. Therefore, there is no urgency. My only, my lord, humble request to your lordship's kind consideration is some interim measure where they will not precipitate the matter further. Because the issue involves the constitutional competence of the state government to carry out a caste census. Admittedly, my lord, in 2014, during the budget presentation, the then Chief Minister and the Finance Minister had made a declaration that for the first time in India, after the year 1931, caste census is embarked upon. Though entry 69 of my lord, list 1 of 7th schedule empowers only the Union of India to carry out the census. I'm sorry, my lords. No, please, my lords.
Yes.
It's only the central government which carries out the census in terms of entry, my lord, the 69 of list 1, 7th schedule. The state government has now done that by amending, my lord, the provisions of the Karnataka State Backward Class Commission Act. Karnataka State Backward Class Commission Act 1995 has got only one role to play. That is, in terms of section 9 of the Act, it can only receive complaints either for inclusion or exclusion of a backward class from the list of backward classes. Even the amendment to section 9 subsection 1 in the year 2014 does not empower the caste census. It only says socio-economic survey. If either the fourth respondent, that is the backward class commission, or the petitioners or the state government even now make a statement that caste will not be referred to, the data that was collected way back in the year 2015 will only be used for backward classes report. Then probably the controversy can be resolved very easily. And one important thing in this case is Union of India had filed statement of objections supporting the case of the petitioners that the writ petition may be allowed on the ground that articles 254, 244 and 246 empower only the Union of India and the state has no constitutional competence. They have included even the scheduled caste and scheduled tribes where the state government does not have any, do not have any power at all. Under Article 330 and 333, it's only the Union of India which carries out the
Caste census, the caste are identified. Every caste is identified,
Yes.
population of every caste,
Yes.
not very, without any object.
They have only
What is the object?
reservation.
Either it is without any object or with any object. Both ways it is objectionable.
I do not wish to submit that the timing of the acceptance or submission of the report is politically motivated. I will only confine my submissions
We are
to the
not-
constitutional and the legal aspect of the matter.
My lord, I do not know from where my learned senior gets this apprehension that something might happen or
No, we are not, we are not.
No, I'm not based on any apprehension, my lord.
Senior is submitting that did come in the form of an affidavit or an application, my lord, so that I can counter it. Just making off the cuff submissions. my lord.
Regarding what?
My lord,
Regarding what?
my lord, whatever he's submitting, he has an apprehension. Yesterday, the report was submitted to the government. We are not aware that it was submitted to the government. I don't know from where he's got that information.
Madam,
All TV channels and all newspapers report that the report was submitted yesterday. And your lordships may kindly take it as a statement from the bar, and I take the personal responsibility that the government did accept the report submitted by the Backward Class Commission after a lapse of 10 years almost. And the chairman who had
2011 it is. For 13 years. Started in the year 2011.
So he is basing only on the ground of legal competence.
competence, please, my lords.
My lord, it's a little sensitive. My lord.
Yes,
will
madam.
grant Sometime, my lord, I will get back to my lord with all, my lord, the information required, because making the oral submission and calling upon the state government to state that they will not precipitate doesn't augur well.
If you have not received the report, then where is the question of precipitate? You be free.
No, my lord, I haven't received any instructions. I haven't sought for
Not received the report.
that writ petition is not listed today.
Which rate, madam?
WB 9258 of 2015.
Now it has come in the additional list.
My lord, that is there. I haven't received.
The state government has filed objections, statement of objections in this, and Union of India also has filed the statement of objections.
No, their apprehension is only that they are using for the election purpose. That's the apprehension you are.
That's the apprehension behind, my lord.
Not, Like I say, has maintained the legal section 11 of the. Instead of these, they are.
My lord may grant us some time, my lord. I'll bring the learned advocate general also.
The report is submitted or not submitted?
My lord, I have no instructions with regard to that. The writ petition
I,
is,
my
lord,
lords,
the
may
writ
kindly, my lord, as a senior counsel, my lord, I take the responsibility of making a submission.
would like
That
to-
report was submitted yesterday by the chairman, Mr. Hegde, Backlog Commission, to the Chief Minister of Karnataka.
Now, next step will be tabling before the House of Legislation.
Either that, or they may have to, my lord, refer it, take a decision in the cabinet, which every Thursday, cabinet meetings will be held. We don't know what is their intention. I'm not asking, my lord, I am not.
For publishing, what is the step? You don't.
My lord,
Whether it goes to the cabinet or.
My
it
lord,
can
it
go to
goes
the cabinet.
cabinet.
The law minister is on record for having made a statement yesterday that it may be taken up either by the cabinet or it may be placed before the house. But even before placing before the house, a decision in the cabinet has to be taken. Whatever decision that the cabinet takes, I don't have any apprehension that it will be hurting the interest of one group or the other. No. My simple submission is, in terms of the constitutional provision, it's only the center which has got the power to carry out a census, especially the caste census. And in this regard, there is a slight background. I'm sorry. My lords, may kindly bear with me for a minute.
Prayer you are making now.
Yes, my lords.
Would stand covered by your original prayer or
Yes, it is still.
read the prayer.
Please, my lords.
Which writ petition?
So technically you may not falter, therefore we are.
Page 12, first prayer is issue a writ of certiorari quashing the order bearing number so.
Which number, which writ, sir?
It's 9258.
9258. Give the papers.
My lords, my lord, the Honorable Chief Justice is right insofar as their petition is concerned, because that has become infructuous.
No, not, we are having 13803.
That's my petition.
That is their petition.
That I saw.
There the prayer is to publish. It is not published, but it is submitted.
No, it is to publish this list, carry out the revision of list
also
of
carry
action
out.
plans.
It
Under
is not.
section 11(1) of the act.
Yes. That is, then the prayer still survives because it is not yet published. It is only submitted. But the prayer in the earliest writ petition of the year 2015 is.
My lord, could I make one submission? My lord may have this on Monday, my lord. I'll get the learned advocate general.
But we can
That
examine.
will we understand the fact.
Very
and
well,
we give.
very
Don't worry, madam. We don't pass any orders.
Very
Wait. Let us understand what is.
Very well.
Now, which is this annexure B?
Annexure B.
Order of taking up social and education.
Yes, page 28 may kindly be seen in that. That's the government order dated 23/1/2014.
Yes.
Page 28.
Yes.
My lords, may kindly permit me to read that paragraph, my lord, so that the things will be clear. In the light of the facts explained in the preamble, I'm sorry, may I read minutes? In the light of the facts explained in the preamble, the government has taken steps separately to the process of bringing amendment to the Karnataka State Commission for Backward Classes Act 1995 in respect of proposed survey of the commission, and also awaited the opinion of the law department in respect of considering the family information collected in Form 3 of survey as non-confidential. Except these two subjects, this is very important, my lord. The government has ordered by according the approval to the following points in respect of caste-wise social and educational survey to be held by the Karnataka State Commission for Backward Classes. But this is completely legally untenable. And that's my the basic challenge.
That's the act. Yavada act ಹೇಳಿ.
At page 56 may kindly be seen, my lord. I produced the act itself, entire act. In that, on page 58, my lords will be pleased to get section 9. On page 58, my lords. Functions of the commission. May I read minutes?
So it doesn't include the caste survey.
No, not at all.
So this is a core caste survey.
The core issue in these writ petitions is
This is the only caste survey, nothing else.
nothing else.
It is not identifying the socially backward class.
No, my lord, everything is based upon caste as the triggering point or the fountain point. Based on that, which is constitutionally impermissible, my lords may also kindly permit me to make a submission. That is, the Madras High Court was pleased to issue a, I'm sorry, my lords. Large issue does arise, my lord.
And it's
And
a
therefore,
sensitive issue.
some sort of an interim order where, my lord,
The factum of submission of the report.
if my lords would be pleased to, if my lords would be pleased to permit, though, my lord,
Record his statement, let them reply.
We record.
Sir, Gurmat sir, Sahabri illa ಹೇಳಿದ್ರು.
We are not disputing the statement as such. But we want confirmation of the other.
please, my lord, please. It can take.
Report ಆಗಿದೆ ಇಲ್ವಾ ಅಂತ ಅವ್ರದ್ದು, they will record a statement. You make a reply for them.
My lord, it may be called on Monday so
Yeah,
that.
we are giving date. We are not passing any order.
Very well.
Since tomorrow, day after tomorrow is holiday, we'll take it up on Monday.
Only one special request, my lords. If it can be taken up on Tuesday, my lords, I'll be grateful to your lordships.
Okay, no issue.
When is there 3 writ appeals?
Beg lords, pardon?
3 petitions.
Three petitions, my lord.
Sir.
Common order will be.
Common order, my lord, common order in my lord, the first writ petition,
Petition is
9258 may kindly be passed.
I wait another 2 petitions. When the caption petitions died down. Came up for consideration.
ಏನಿಲ್ಲ, ಏನ್ ಟೆನ್ಷನ್ ಮಾಡ್ಕೊ.
Let us hear prayer, viewer, Mr.
My lord, it's on page 12, my lords. Please, my lords. The first prayer is issue a writ of certiorari quashing the order bearing number so and so, dated so and so, passed by the third respondent. Then strike down the amendment to section 9 of the 1995 Karnataka State Backward Classes Commission Act so and so, annexure F, passed by the third respondent.
My
Both
lord,
still,
they are served, but they are not represented
my lord,
also.
amendment is, my lords were pleased to, my lord, read just a while ago, what is section 9 of the Backward Class Commission Act. An amendment is brought. Even in that amendment, it does not empower the Backward Class Commission to carry out a caste census. It still refers socio-economic backwardness without reference to the caste. The first ground of challenge to the amendment is it's ultra vires the act itself.
Writ petition 925850, another 2 writ petitions. In the caption, the petition is directed against the order dated 23/1/14.
Dated?
Which figures at annexure B in the compilation of the bit. Passed by Respondent, who is Respondent? Passed by Respondent, to take up on number. As per the decision, as per the impugned decision, comma, the state government is ordered to proceed to undertake the caste-wise social survey.
Please, my lords. Social and educational survey.
Social and education survey. To be undertaken by the Karnataka State Commission for Backward Classes.
Fourth respondent.
That's the 4th response. The prayers in the petition also made to strike down the amendment to section 9 of 1995 Karnataka State Before Classes Commission Act. The decision to proceed with the caste survey by the state of Karnataka has been questioned by the writ petitioners.
Page 11 vacant.
Grounds enumerated in the petition, which all are centripetal to the legal and to constitutional and legal competence
Please, minutes.
of the state to go for caste survey. When the petitions came up for consideration, from a learned senior advocate, Mr.
Gurumat.
made a statement before the court that the state government has that the chairman of the
Fourth respondent.
Backward Class Commission
Please, minutes.
has already submitted the caste survey report
Please, Chief Minister.
to the Honorable
Chief Minister.
Full stop. As the responsible statement is made by the senior counsel, the court calls upon the
Government.
respondent appearing to the government advocate to confirm or otherwise the factum of submission of the report.
Please.
Not to inform.
The government, learned government advocate should respond by putting the necessary facts on affidavit.
Please. Please.
Not before Monday.
Tuesday. God bless you, Lord.
My lord, I'll have to file it by Tuesday. I have to file it by Tuesday.
Tuesday, madam, there you reply the statement made by Mr. Gurmat.
Form of affidavit.
Report.
Yes,
My lord, my lord's permission. My lord's permission. Serial number 75, my lord had posted it for next week, so I did not hear the date. My lord, it is on the
75
12th,
date.
my lord. I am in Bombay for a case, my lord. Kindly have it on 11th. 11th. 75 at 11th instead of 12th.
No, it is already given 11th. 12th. 12th,
11th,
okay.
11th. I've informed the other councils that I'll be requesting this day.
11/3.
Return of fees. Return of fees.
Yes, my lord.
Your Lordship, serial number 66, respondent had sought time and your lordships were pleased to post that matter on Monday. Some inconvenience of Monday, may I request your lordships on Tuesday
What is the matter? What was the matter?
that with regard to demolition, there was violation of plan while construction.
Which matter, sir?
65, your lordship.
65/4/3, Monday.
Tuesday, your lordship, Monday, some person.
Okay, you inform the others.
I'll respond, I'll inform.
Okay, no issue.
Much okay.
That only one result made this one. We want the child.
Please, minutes, please.